Lordship, I crave leave to mention a matter. Your Lordship, we crave leave to file the appeal without the certified copy. Your Lordship, the order was passed yesterday. The server copy is available. So this is the server copy, Your Lordship.
Have you applied for certified copy?
Yes.
We applied for the certified copy yesterday itself, Your Lordship.
Arising from where?
But it is a Group 4 matter, Your Lordship. The writ order has been passed by Honorable Justice Rashi Bharadwaj, Your Lordship, having determination over Group 4, Your Lordship.
Give.
Grateful, Your Lordship.
Lordship, I also crave leave for filing this memo of appeal without certified copy.
When the order is passed,
Lordship, 20th December.
have you annexed the server copy?
Yes, Your Lordship.
Have you applied for certified copy?
Yes, Your Lordship.
Have you annexed the photocopy of that application?
Yes, Your Lordship.
Give.
Grateful.
Lordship, I crave leave to mention one original side matter. The client was to withdraw the matter due to he wants to avail the Vivad Se Viswas scheme.
Huh? What avail?
Avail the scheme of Vivad Se Viswas.
No, there's certified.
Okay.
It will appear after the vacation.
My lord. Grateful.
Your Lordship, may I have Your Lordship's leave to mention item number 16 and 17 of Your Lordship's list, Your Lordship. This matter may be kindly be heard today. As Your Lordship, the contempt matter is being listed on 3rd of January, Your Lordship, which is item 16. And in item number 17, there is a...
It will be listed on
Your Lordship,
second.
it is listed, Your Lordship. I am praying that the matter could be heard today.
Or we may reach 17 also.
Obliged, Your Lordship.
Call the list.
Appellate side daily list under the heading for judgment, serial number 1 and 2.
For the reasons as aforesaid, the order of the learned single judge dated 23rd of February 2022 as well as the order impugned in the writ petition dated 14th of January 2022 passed by the Income Tax Settlement Commissioner set aside and quashed. The application of the petitioner dated 17th of March 2021 filed before the Income Tax Settlement Commissioner stands restored to the file of the Settlement Commission. The interim board is directed to consider the said application in accordance with the scheme that may be framed by the central government as in respect of the cases which arose prior to 31st of January 2021 and to decide the same in accordance with law and on merits. The appeals accordingly stand allowed.
Serial number 3.
Great.
To be mentioned.
This was mentioned yesterday, my lord.
Why to be mentioned?
But because, my lord,
in person.
as against an order passed by the division bench in, my lord, the public interest
If it is
litigation, my
already
lord,
mentioned, then why to be mentioned?
my lord,
If it is already
because I was
mentioned,
seeking,
then
my lord,
why
for
to
an
be
interim
mentioned?
order, my lord, in the meantime. I was seeking for an interim order in the meantime so that
The
they do
matter
not
is
proceed with, my
pending,
lord, the demolition of, my lord, the hoardings that my clients have erected lawfully. But the directions were, my lord, for, my lord, dismantling of the illegal hoardings.
The matter was already taken up on 21st of November. There is a direction pass.
But as against that order, 21st, blood, there was a blood
That they will
SLP
serve a
preferred.
notice on all legal advertising agencies or the persons who erected such illegal hoarding and advertising.
That was not done by Milord, the Bidhannagar Municipal Corporation.
So let them go and find out. Let them.
But there is a direction, Milord, for joint inspection pursuant to order passed by
They
the
will
civil
go
court.
and ascertain that which are illegal and which are not illegal.
Yes. So, my lord, before that, they should not be demolishing. Already, my lord, 90
For
of my.
demolition, the order is very clear.
But they have already 90. আমাকে দিন না, 90টা কোনটা
Nothing,
পেয়েছি।
they can't do anything.
Lordship, may I bring to your notice that before this, Can 3 and Can 4 was filed. One Can 1 and Can 2 was also filed. And after that, before that, actually, they have filed one SLP in the Supreme Court, which has been dismissed on the last occasion.
Liberty, with the liberty to approach before this court.
Maybe, sir, but the order has
Sort
not
of.
been there. The order says that they will serve a notice and then they will take steps for demolition. So they have to serve a notice.
No notice, my lord. Kindly
So
come.
no notice, so they will take.
We have already started demolition. We have
After notice, if they have,
They have not, my lord, given any notice.
what are you talking of?
Yes.
But so
There is
far as
a
my client is
Calcutta-
concerned, Karupkrit,
Calcutta-
my lord, I have a license.
No, I am for the corporation, madam.
Yes, why?
We have issued, my lord, notice, my lord, in terms of the order passed by the Honorable Chief Justice, my lord. 48 hours notice, my lord, time was given to the persons responsible for the illegal, my lord, display, my lord. My lord, I have it, my lord, will kindly pass it over, my lord. I have the entire brief, my lord, with my leader, my lord, who is assistant.
Sir, you know this matter is a first matter and you do not have a brief.
My lord, I mean,
Your
absolutely
senior must have a brief. He's carrying with him.
my lord,
Is this a way the Calcutta High Court lawyers, they conduct the cases? Unheard of.
my lord, my apologies to your lordship, my lord. I
Oh,
have it, my lord. I have personally
Sorry, so
seen-
why don't you give it? That you have given a notice?
ভেঙেছে আমাকে একটু দেখাও না, ভেঙেছে ছবি।
না, না, এটা report টা না। এরপরে একটা হয়েছে।
Mr. Mukherjee, only one thing,
পরে
your
একটা হয়েছে।
allegation, submission is that this demolition is being carried on without serving a notice, then you could have filed a contempt application
Yeah, okay.
because there was a specific direction that after serving this has to be done.
No, my lord, there are 2
If you
points.
allege violation of this order, then
Lord,
remedy lies-
I'll tell you, Lord. Your lordships are very specific that, Lord, it should be directed against the, Lord, the illegal advertisers. That was, Lord. So identification of the illegal advertisers was, Lord, in the domain of the Bidannagar Municipal Corporation. They did not do so.
Sir, if they have issued a notice,
sorry.
that means that they have already undertaken that exercise and these hoardings are found to be illegal. If that being the position, then you can't say anything on that. You could have come before the court for this, that your permission is there. You have erected it, but I don't think so that that can be done.
Lord, your lordship will kindly see in that, Lord, the order, there were, Lord, a report before this court. The report says that, Lord, excepting 2, Lord, there are other, Lord, illegal advertisers. I say that I fall within that too. Because I had an agreement, I have paid them, and, Lord, I have erected the uniposts which they are not
Sir,
touching as
let
of
them
now.
dismantle. If this is a genuine one, we will take them to task.
Lord, there are
Take them to task.
470, Lord, kiosks.
If they dismantle it after having granted you a permission, then in that event, they will be held liable for that. The court has said only the illegal hoardings that has to be demolished. Nothing more than that. Why you are apprehending? If you do not fall within that,
Lordship, I'm appearing in person. I'm the applicant of the writ, the public interest litigation. On the last occasion, Your Lordship, they have
Sir, one
given a schedule
Only 2
of
agencies are
statement of
paying
polls kiosks at Salt Lake City. But the order of 21st of November clearly states about the hoardings, Your Lordship.
correct.
Now, Your Lordship,
Kiosks are those
Now-
which are fixed on the lamppost, the small ones, 5 by
Understand,
4.
sir. The kiosk are the two. One is the kiosk is set up on the side of the road
Yes, sir. At
for sitting purposes, monitoring, surveillance, everything can be done. And this kiosk can be also be put in on the board or a lamppost or
Lamppost.
something. There's no difficulty.
But here, Lord, about the, Lord, that kiosk we are talking
We are
about.
not concerned with that. The concern is with regard to the hoardings, the court has said.
আমাদের তো hoarding নেই।
Absolutely.
See, let them
আমাদের
come, let them demolish, come with the instance that they have demolished beyond the scope of the order. We'll see to it, but
Absolutely.
you can't apprehend something.
Absolutely, Your Lordship.
They may not do it,
Absolutely.
but they have taken a drive in terms of the order for demolition of the hoardings,
Yes.
illegal hoardings.
Malad, kindly consider, Malad,
Not consider, Jabardast.
Malad, করবো।
But kindly consider the prayer of the writ petition once.
Not necessary, sir.
But kindly,
Have you challenged this order before the Supreme Court? 21st. You could not succeed.
my lord,
Lordship,
since my lord, the Honorable Chief Justice is available, Lordship kindly appreciate the order of the
Lordship, kindly let me
This
intervene,
is
your
the
Lordship.
last order of 21st of November.
My lord, thereafter, my lord, we come before your Lordship, my lord, with a review application. Your
And
Lordship,
then review will be decided by that bench. We can't
yes,
decide the
that
review.
is the reason, my lord, we approach
That's all.
before the Supreme Court. Now, my lord, the Supreme Court says that since the Honorable Chief Justice is available, go and approach the Honorable High Court.
Your Lordship, kindly,
Sir, how many times you have appeared there? Have you? You know when these orders are passed?
My lord,
Oh, very well.
absolutely.
How and when those orders are passed?
Lordship, kindly appreciate one thing. My
We
lord,
appreciate everything.
Malak, kindly see the prayer of the writ petition. The basic, Malak, the first prayer is the identification of illegal hoarding. Malak, the first prayer of the writ petition is the identification of the illegal hoarding.
And dismantling them.
Now kindly consider, Malak,
Why you allowed this 21st November order to be passed? If that is your first primary
Malak, we are not made
primary
party.
contention, sir, then why you allowed this order to be passed?
Malak, we
And
are
if
not
this order is
implicated as a
passed,
party.
this order is passed, then it has to be implemented so long.
This order has been placed behind our back, Malak. We have not been implicated as a party.
Not, it's a in rem.
But Lordship, kindly consider the
One rule 8,
kindly consider
binding on you.
kindly consider the prayer of the writ petition.
Sorry, if you can show them that you have a genuine permission,
Let them
But
see first.
sorry, let them. If they give you a notice, you have to go and.
They have not given any notice, but and started
say
for
that
demolition.
Lordship,
They are
please,
supposed to give a notice. That
Then Malad kindly give a direction upon them to give a notice. Then Malad they start for demolition.
That
Let
order
them
is already
declare
there.
an order.
That order is
Paragraph
already
4 of
there.
the order.
Malad, this order has been passed on the basis of a
Now
submission
you
made.
make your submission, I will not react to it. I
Malad,
know
kindly
what
say,
it
Malad,
is.
this order has been passed on the basis of a submission made by the Vizianagaram municipality that out of 351, 349 advertisers are illegal. We do not know, Malad, who are these 349? Number one. Number two, in the order itself, Lordship find that the Vizianagaram municipality says that they issued a notice. Let them show a single notice issued to any of the advertisers. Any single notice.
Bhattacharya, if your hoardings are legal, then why are you apprehensive?
Because in my application, page 93, I have annexed
You
the
come
photograph.
and say that I come within 2. You come and say that I come within 2. Now, if there is only
But I have
2
annexed all
numerical
the
number,
document.
how many people have?
No, blood, I am an individual advertiser. Blood, and my learned friend is appearing for an association. So, blood, there's a bit difference between the two, blood. So far as my client is concerned, Karupri,
License
blood, they are blood, an association of the outdoor advertisers.
as an association?
My members of the license.
That's all.
Malad,
The member come, it's an individual infringement of the right, not a collective right.
Malad, page 16, Malad, of my application, I have given Malad the specific
Mr.
details.
Bhattacharya, some of your members may have put up legal hoardings, some may not.
Yes.
So how can you canvass in case of all the members?
Our only prayer is let them identify, let them issue a SOPAS, Malad, let them declare our hoarding as illegal.
Blood, so
then
far,
they start for demolition.
so far as my client is concerned, they have already issued a notice. Blood, kindly have a look at the notices.
Illegal hoardings have mushroomed in the entire municipal corporation area of Bidhannagar, which was flagged by the petitioner in the instant public interest litigation by an order
বেরো আগে আগে তোর মাথাটা পরিষ্কার দিলাম The appear for the state respondents. Bolo, bolo.
My lord, in this matter, service not completed it, and also
They are
the
appearing without service.
yes, my lord,
They are appearing without service.
full service
That's
not completed.
beneficial to you.
Kindly check it, my lord.
That's beneficial to you.
My senior is not there.
And also my learned senior is not well.
See the real ground. Once they have appeared, then why you are taking a plea of service?
ठीक है छोड़ दो
After vacation, not
After
today. Next.
next वाला brief बंद बोलो
Serial number 5.
The
Lordship,
appear for the
I appear for the petitioners. Lordship, I
Your
prefer
facial expression shows that you are asking for adjournment.
not today. Yes, Your Lordship. So, Your Lordship, due to personal difficulties of
Not-
my senior counsel.
not today.
Not today.
Not today. Serial number 6.
Wait, please. I'm appearing for the appeal.
One is not. I appear for the state respondents in this matter.
He is very apprehensive. That shows that he does not have a good point.
No, my learned senior is looking for the central GST authorities. They are the answering respondent and they are not present here.
I just thought that he's very skeptical about it. So I just thought that he's not sure. Yes.
My lords were pleased to grant expeditious hearing of this matter. But the lordship, the reason was this, that
Any emergency situation?
they had fixed the hearing yesterday, and the writ petition was moved on Friday. So the hearing was yesterday. The learned judge was pleased to dismiss the writ petition, and therefore we served them and requested them not to proceed with the hearing. And the matter was mentioned before my lords, and my lords were pleased to have it.
What has happened yesterday?
We have only made a written request. We have no information, but and that was
Where is the GST authority?
I'm
Have you given them a time because they wanted to pursue the remedy? So the writ petition has been dismissed, but they have come up. So during this vacation, are you going to take any drastic steps?
Not drastic, but I have to go ahead with my adjudication. My problem is
Is there
under
any
section
time
74,
limit?
yes.
Is there any time limit
Yes, I have to,
in which you have to complete
5th of 2025.
what?
I have to complete 5th February 2025. I have to complete my adjudication and I have to give the portal upload. It's like arbitration, and after 121 days, even court cannot condone my delay. So Lordship, in that case, I have to proceed. If the Lordship looks into his matter,
Then you did not have to. I was just thinking whether is the last day before the vacation, so that's why I was thinking anything, if it can be postponed to a reopening,
I think
the
it can be
regular
done on
thing
the
should be there.
Lordship, then in that case, let me proceed in between time, because the proceedings is having a certain paraphernalities which has to be done. Let us proceed with that. If he gets a chance, if he succeed in his writ appeal, then Lordship, he can always add on. But today, I am calling him to make a representation. I will try to demonstrate from my show cause that what I am.
It is something very, the intelligence department has gathered certain information in the search operation.
Essentially,
You wanted that principle of natural justice to be followed because those sensitive information should also be disclosed to you.
I do not want the sensitive part at all, and that's why the learned judges, in my humble submission, heard, because that was never my prayer, because I relied upon a judgment which says that redact the sensitive part.
that is not to be disclosed to me.
That's true.
So, Leonard Judge has dismissed the writ petition only on the basis that as if I'm seeking the sensitive part. I'm not.
And what you sought?
No, there's an investigation which has happened, investigation report which is there. Now, the show cause notice speaks about the investigation, and I was requesting for a copy of that because I had paid GST. I had paid on a turnover of 719 crores over a 5-year period.
Your junior was mentioning that they have raised a demand of 6,000 something crores.
Yes,
when your total turnover since last 5 years is
719.
19.
719, and they have 6,000. So the entire I have to be very careful in how I deal with this matter. And if something is available to me, they've referred to in the notice, I would be humbly submitting.
What game you organize? Because your name says gaming.
I have an online platform, where different games are available. So individuals who want to play the games, they log into the platform, they pool in their own money, which the winner takes. I get a small percentage of whatever they pool in, which is the platform fee. So now on that platform fee, I pay taxes. Now they want to change the nature of the transaction itself and say that I have to.
Is it permissible in law? This kind of a platform, the gaming,
yes,
or
it is permissible.
So far as IPC is concerned, I'm not aware. But so far as my case is concerned, that if you are allowing someone a platform, how he is doing, kindly see.
No. He is doing that. He is providing an avenue to the gamers to come and play
between themselves
in his space, which he provides, the space which he provides, and the facilities which he provides.
And both of them are putting money.
Technology, everything. Now he says that since you are using my space, you are using my area or a platform, whatever, then you'll have to pay certain fees.
No, not only that. He has a wallet with him also.
Now the question is, wallet is as a custodian. If somebody keeps the money as a custodian, say for an example, a transaction, say the sale of the HON'BLE property attracts a GST. Let us hypothetically understand. An agreement for sale is entered into, and then a substantial amount or a sum of the amount is taken. Sale is not complete as of now. This amount remained with the vendor, the owner, to be adjusted and appropriated the moment the sale deed is finally confirmed and the rest of the consideration money is there. Till the time that sale deed is not complete or the remaining consideration is not paid, whether this amount which is received as a custodian, which can be refunded because in the event the sale fails, will be chargeable under the GST, or it will remain postponed. I'm just thinking.
Yes, absolutely.
Postponed, and it will attract GST the moment the sale is complete. What is your reaction?
It will not attract, but my case, if I may humbly put it,
because the wallet.
No, Lordship, but I'm
really a custodian of the
money. No, if it is
because that money would be utilized by those gamers,
not by
the moment they log into the platform and then use that money.
True.
So he is not really earning
anything out of
that because it is to be used by
them
as a wallet. That's why I gave you an example.
Now, if I take that example as a clue and a reply, if it is refundable in nature, all right. But when the money, like now, just come to the bank side. Money kept in bank. Moment I enter a service for that, then the service tax comes into play.
True.
Now here,
when the service will come,
when he will deal with the money.
Yes,
he will deal with the money, not barely deposit and return back. Lordship, kindly come to page 170. Kindly, exactly, Lordship is on that point. 170. 117. Exactly by question and answer during investigation. This is a show cause notice. In the show cause notice, exactly I have given that picture. That how you are dealing with the money and how you are evading. Lordship, kindly see. Two persons are gaming.
Question number?
119. 19.
Yes.
Lordship, two participant.
Just, it would appear that you had a company charged and paid such on the face value of the event.
Kindly see, both of them are giving 100. He is holding 100. GST he is giving 0. Then he is taking his one, and then he.
Okay, you are putting a question as if that his business policy is absolutely wrong, because he is charging more than in relation.
No, Lordship, I'm coming to that. No, I'm coming to that. This is the pattern he is following. So he is then taking that 100 rupee and giving back to someone else. Then he is dealing with the money. He is substituting it to the winner.
No,
Moment he is dealing with that money.
What I'm saying, there is the distinction has to be done.
Now, Lordship, kindly come to the next one.
Suppose a custodian of a money.
Custodian
utilize that money.
He
has to return it to the main owner of the money.
No, Lordship, that's the
owner utilizes the money. Then and then.
No, owner cannot. So, Lordship, one is losing, one is winning. Moment one is losing.
They are always the winner.
No.
Even a loser have to pay a certain amount.
Winner has Lordship, this is a wagering. This is a wagering contract. He is keeping the money with him in a wagering contract, and he is dealing with the money because he promised to the other man, then I will give you this if you win in the wager.
That's all in all.
No.
Mutual fund is how I
What? I could not get it.
In a wager, yes, I'm getting. He is the platform, he is not only playing.
He's not playing.
No, he is providing the playing. Then he takes the money in his hand.
Yes.
Now it is his, no, not as a security.
Suppose a security.
No, it's a positive promise to him, by him.
Because the reason is that he will not leave the platform because that money is lying with him. So he has to come and log into that platform. That's a business tactic.
So, no. Then he is holding the money for whom?
He's holding the money on behalf. For whom? No. On behalf.
No. He cannot. He can only hold the money if my money.
Suppose the nominee, if it is given. In many banking transactions, in many other the insurance, there are many other.
Lordship, nominee in a wagering contract and in a.
Merely a custodian. Suppose if he goes, he collects the money. Does he become entitled?
Anyway, that is a matter of adjudication, Lordship. I will come back to that.
Oh.
Now, what today we are arguing before.
LIC judgment against you of the Supreme Court.
I'm not aware of Lordship. Then Lordship, kindly come to.
What is the role of the nominee? He's merely.
No, that I know. He is a custodian. He has to distribute amongst all legal heirs. Lordship, that is there. He has to distribute among all legal heirs.
It's a charge করা উচিত. The moment we give the play হয়েছে, winning and lose হয়েছে, then
now Lordship
a certain percentage from it, and that will attract the GST.
Lordship, kindly see why there.
There's a slate face because he says, I think he is of the view that the court is going in the wrong direction. Let him go. And keep him silent.
No, but I'll explain.
No, that is what I'm not confused. I'm confused.
It's not a confusion.
No, sir, my confusion. Sir, 31A says, how the rule 31 says, value of the supply in case of a lottery, betting, gambling, and horse racing. I have a particular rule to that extent.
100%.
So the total amount has to be taken. What he is 100 and 100. The entire money.
I do not know what is the modalities there. Suppose as if
Lordship, today let's.
The person he says that I want to play the game. I am a big gamer.
That is.
But I am having now say 10,000 rupees in my bank account. I transferred or converted that 10,000 rupees into their wallet which they have created.
Right. Lordship is.
So it is really I would say the transfer of a money or passing of a money from one source to another, from one place to another place. That is
true.
Suppose I do not know what is the software. That person later on realized that no, I do not want to play in this platform.
He cannot go out. His money he is already deposited.
His money to be returned.
Yes.
They are bound to return.
Yes. Yes.
Keep it. If they keep
Yes.
it, then they will be exposed under a different panel.
Lordship. Lordship.
So in that event, if that being the position,
Yes.
the wallet would be only that he's holding that money, but not
Right.
utilizing it
Right.
for any benefit.
Right.
The moment the owner of the money, he utilizes the money
Understood, man.
on their platform, then the amount of utilization would attract the I would say the tax
Lordship.
liability, not the mere
Lordship.
keeping a money in
Lordship.
the wallet will not attract.
True. I am agreeing with you.
Where is the problem?
Lordship. Now, Lordship has discussed the entire thing with me, whether the GST will attract or not. Did Lordship enter into any question whether my investigation report was what? No, Lordship did not ask me. This is the job of the adjudicating authority. We are asking him, these are the statement I collected. This is the tax to be paid. This is your business model. This is my law. So according to this will be the demand. No, this is what fallen from your Lordship. Correct, incorrect, that's a different issue. He has to convince my adjudicating authority. So that's the reason why I tolerate to convince your Lordship that exactly the discussion I said, no, it is applicable. Lordship said, no. Lordship has given me example. This discussion is going to happen before an adjudicating authority. And for that purpose, Lordship, neither we need. Yes.
What is the role of a court? What is the role of the court? If the court finds that the adjudicating authority under the statute is acting beyond the powers which is conferred,
Lordship,
blatantly in contravention to the law which is there in place,
Lordship can quash my show cause notice. That's not the challenge they have thrown me.
no difficulty. In order to ascertain that whether you are within your powers, you say that they were keeping a money in your wallets. That's why
That's right. That is exactly the adjudicating authority will discuss.
Let us discuss whether this wallet attracts. Yeah, wallet attracts.
So if Lordship is today if we are talking today before your Lordship on basis of the validity of the show cause notice, that is not under challenge.
Now suppose I am talking about the income tax perspective. I have earned, I have shown, I have paid the tax. Now it is me, either I can keep that amount after payment of the tax in a bank or in hand. I keep it in hand, which will not attract any other income. If I keep it in bank, then the bank will give me an interest and the interest will again be treated as an income.
So
suppose in hand, I keep it. It does not. Can you say why you are keeping in hand?
No, Lordship, today.
I fully tax paid money.
So, Lordship, whether
that will come later on. I'm talking about if there is no restriction of keeping.
No, not keeping in of course, there is for a purpose of gambling, that's a different. So, Lordship, today the show cause notice is not under challenge.
Making any income from that wallet is intact. They can't utilize it.
I don't know. I don't know.
Have you got
investigation and adjudication will get it.
By making any investments anywhere?
Lordship, that's what I said. Lordship, what I will submit now before your Lordship. If that is the purpose of the adjudication, what we tried to do superficially here, the adjudicating authority will go into it. So for adjudicating authority, what we need is. So, Lordship.
So this adjudication has to be done within a time frame.
There is a time frame, but not if the court is pleased to. But I must indicate, there's a originally writ petition was filed, not challenging the notice. Provisions, the law. So, our court was pleased to entertain it, and was pleased to direct that I should submit a reply. The adjudication order will not be given effect to. So, and then the revenue, because there are several such writ petitions all over the country. Revenue filed a transfer petition before the Honorable Supreme Court. Those matters stand transferred there. So, that larger question will be decided there. Now, but when this adjudication proceeding has started, so I made the request in January and February 2024 for this particular investigation reports, which are investigation which is referred to in the show cause notice. But the authority, the Directorate General, they said that you take it up with the adjudicating authority. So I wrote a letter to the adjudicating authority in February, 15th February. So they sat over it. Then in November, end November, they fixed the hearing for the first time on 3rd December. So I sent a letter that I've already put in this request for these. So please give me that. And in any case, this is too short a notice. So they do not deal with my request. They fix another date of hearing, which was 23rd. So they are not dealing with this particular request of mine. And regarding the copies.
What is the period within which this adjudication has to be completed?
5th February 2025.
25th.
No, 5th February 2025.
Within 1 year. Limitation?
Limitation is actually the notice was issued on 28th of October 2023. 28th October. So the time will be calculated. It will be in February.
Effective
But
date.
if the court is pleased to stay, then that period will get excluded.
No,
It's not that.
no. No,
In
that's
any
not.
case, presently, since we are on the last day, I can get into the merits insofar as my claim is concerned. But in fact, there's a decision of the Honorable Bombay High Court on a similar situation, my parent company, and there the Bombay High Court was pleased to direct the investigation report to be disclosed after redacting the sensitive part. That was the decision which I had relied upon before the.
What was that decision? Why the
learned judge was pleased to observe that it's not binding on me, and I. So
it has a persuasive value.
Yes.
It has a persuasive value.
Investigation report investigation report this is 3245
এটা কোন ডিপার্টমেন্ট?
ওই যে বম্বে হাইকোর্ট থেকে ওনারা রিলাই করছে
ডিপার্টমেন্ট কোনটা?
এই ডিজিএসটি ওখানকার বম্বে 30
ওইটা বের কর।
ইন্টারনাল ইনভেস্টিগেশন রিপোর্ট আছে এখানে দেখুন আমরা কিভাবে র্যাঙ্ক করেছি investigation report they include so could not relate
Just give me a hard copy of the ground. Just give me one.
So it is a withholding of the the sensitive information, which according to you never sought for.
No. In fact, the judgment that I relied upon that says that that has to be redacted. It is not to be given to me. So it is not my prayer at all that I should get something which is sensitive. But there is judgment of the Honorable Supreme Court in the case of Takano, which was considered by the Bombay High Court, and thereafter the particular direction was given. If my lords are
sensitive information, why they will not disclose all this? They are adjudicating authorities and they are adjudicating on the basis of materials which would be there. Why don't you give them all the information except the very, very incriminating
sensitive part? They don't know.
Sensitive information.
Lordship, let's know. We will not go on a theoretical basis. We will come to show cause notice. We will go one by line. I will show there is nothing relied by my department, which,
then on what basis?
and then I have given him a letter. Lordship, he has to somehow cross that time bound. He is trying and fighting to cross me over 5th of February.
No,
Lordship. Now, Lordship, what I'm saying is I have given him a letter.
When is the next date fixed?
Next date I am not aware of because adjudicating authority can tell Lordship. I am appearing for the intelligence part, Lordship. Now, Lordship, what I am saying,
We have seen that Takano judgment, and the learned judge was of the view that he is really seeking sensitive information.
No, Lordship, kindly
says that it cannot be justified. Now, suppose you have issued a show cause notice. If you have issued a show cause notice, they are supposed to give a reply, which they have replied,
15th February, my lord.
which they have replied. Now you wanted to adjudicate it.
Yes, Lordship.
That means if you have not disclosed any document,
I will be not allowed to be ruled upon. I have declared this.
again saying, if you do not rely upon any document, no difficulty, adjudicate on the basis of whatever the so cause and the reply.
Lordship, I have given a list.
If you rely on a document,
I have given him a copy.
where is the copy?
Yes, Lordship, he has acknowledged. Kindly see the show cause.
That is
Lordship,
what-
kindly come to my show cause once.
Sure,
Kindly come to page 95.
sure.
Yes, yes.
So,
Each document I have given inspection.
we
Yes.
wanted that.
Lordship, kindly come to page 95. P1, show cause notice.
Yes.
Now, Lordship, kindly come to show cause notice,
Yes.
which starts from 95. Then I said that I have done. Now, kindly see para 3.
But if my learned friend will not allow me, kindly not see page 95, the opening paragraph. my lord. Page 95, the opening paragraph.
No, Lordship was indicating.
No. I have taken leave. Please, no. You can
Of
keep it.
course, but once. Of course, then as I am called upon by my lord, so I am trying to. Lordship, kindly come to para 3. Lordship will find that RUD1, RUD2, RUD3
That is what we find.
relied upon documents.
The Panchanama
Lordship,
statements.
Huh. Lordship, kindly see this all document, relied document I have annexed. Now, Lordship, kindly come to page.
These are the one is the Panchanama. These are, and the second one is the statements which you recorded.
These are the document I am relying. Lordship, now come to. Now, Lordship, again come to.
Then there is no other document.
Yes. 20 documents, Lordship. 20 documents. Then page 100.
Then
Page 100. Lordship will find RUD4.
the statement. I am faster than you. I know page 100. I know 3.6.
Yes.
I have read it.
102.
On the basis of the another notice under section 70,
Lordship.
you have recorded the statement. That statement was part of RUD4.
Whatever are you? Now, kindly come to 529.
I am just trying to decipher any documentary evidence which you gathered. These are the statements which you record at the time of search and seizures. You record the statement. These are the statements which you have relied upon. This is what I really wanted to invite your attention. If you go by a statement, let them decide whether these statements are sacrosanct and can be relied. No difficulty.
Kindly now come to 529.
And copies of again statement on the basis of summons RUD 567 3.8.
So kindly come to page 529 once. 529. Document will find Lordship RUD 14.
529. Yes.
Yes, list the document.
Kindly.
Panchanama,
Yes.
statement. Then certificate is
Yes.
given.
Signed
The
document.
signed copy of the statement.
Then screenshot.
Statement.
Admission
relevant
certificate.
provisions Showing the explanatory note, classification. Then the printout of the web portal.
Lordship.
Then have you given a printout of that?
Yes. He has received it at the bottom, Lordship.
Not relied upon documents. Next paragraph.
And then next page is not relied upon document.
Receive this.
He also seen that.
The original inspection has been given.
Now, ওই চিঠিটা বের করে যেখানে আমি বলেছি আর কোনো document নেই।
541.
And then Lordship 541.
Yes.
530, non-relied document.
Yes.
That also he has taken inspection, Lordship. His lawyer has taken inspection.
Yes.
Now 541. Then I surrendered before him in the month of February 2024. I have no more document to give you. These are the documents I will be relying.
Right.
541, Lordship.
Yes.
Then Lordship, then in show cause, whatever document I relied, I have given him. He has taken inspection. His lawyer has endorsed signature. Then Lordship, in the next, the document, not relied document we have in the file, but we are not relying. That also given. That is page 530.
That is the law that they have to be given those because they may rely on that
Lordship.
document.
So we have also given them. And then Lordship 541, where I said that I have no other document to rely on. Khaitan sir poll. Now,
What more?
But kindly look at the
All
notice.
the documents which they rely upon, they have given you an inspection of those documents. And then you have given a reply. Now you know the scope of interference against a show cause is very limited.
I'm not on the notice at all.
Limited.
Lordship.
The court will not substitute its finding. Now, adjudicating authorities, you go there.
No, can you not look? Can you have a look at the notice once more? Just the relevant portion. I have not trouble, my lord. With.
What is there? Vagueness, any all these things. You take a plea.
No, Lord. Question is not if there's a violation of natural justice, not it means the clock will have to be put back later. So, Lord, I'm trying to avoid that situation where, Lord, I get the fullest opportunity and the matter is decided once and for all. But can you take page 95? 95.
Yes. Yes.
But intelligence was shared by the Directorate General of GST Intelligence Headquarters, New Delhi, and was further developed by the officers of the Directorate General of GST Intelligence that Messrs. Delta Tech Gaming Limited, known as SONSO, are engaged in online, web-based, mobile-based supply of actionable claims, namely betting, which they were showing as online games like poker, rummy, fantasy games like contest-based, content-based cricket, football, etc., have contravened the provisions of so-and-so. So what they say, intelligence was shared and developed. So now I'm going to kindly see what they say thereafter. At page 96. In fact, page 97. 3.1. Acting on the basis of intelligence. They issue the search authorization.
Yes.
Now I'm going to kindly see the page 100. 3.5.
Yes.
Accordingly, a team of officers of DGGI KZU visited the taxpayer's Gurugram office at so-and-so with authorization for inspection under section so-and-so for the urgent follow-up investigation. So they talk about intelligence, they talk about investigation. So investigation would have resulted in a report. They refer to it in the notice. If there was no reference to it at all, I would not have been before my lords. They refer to it. They issue a show cause notice, which is 10 times my turnover in the last 5 years, and I have to be given everything which is being relied upon. They have referred to it in the notice. That is good enough. Whether they call it a relied upon document or not, in my humble submission, because this show cause notice would not have come into existence without the report. The investigation report would have to be there, because this, in fact, in course of the inspection, it was said to my client, and we recorded it in a letter, that they are saying that yes, it is there in the soft form in their system. But then, when I pressed for that, they said, we will not give it, you take it up with the adjudicating authority. I wrote to the adjudicating authority in February, 15th February, I wrote.
That's page 541.
And there's a written document, and they did not respond to it. Then they fixed the hearing in late November.
They may not rely upon a report.
The question is they have referred.
They might have, but they do not want to rely upon the report. They have to go on the basis of whatever the materials which they have. If ultimately the adjudicating authority may not be in a position, and the moment they wanted to rely upon the report, you may raise an objection.
The moment this is referred to in the notice,
that report
kindly let me make submissions.
They may have said many things, but they have not relied upon any of such documents. And then if they want to rely at the time of an adjudication, maybe recording of the evidence, I do not know what is the procedure which is followed. So if they want to record a further evidence, if they want to put those, the papers in evidence to form a basis or form an opinion, then in that basis, if they want to rely, you can raise an objection. This is violative of the principle.
I have already requested for it. They are keeping silent on it.
Suppose if they do not, then what is the
kindly have a look at the Bombay judgment.
একটা document আমার কাছে আছে, but আমি rely করতে পারছি না.
Kindly have a look at the Bombay judgment.
To my interest.
Kindly have a look at the Bombay decision.
Detrimental to my interest.
The court in Bombay, the court was pleased to ask them to put it on affidavit, and then they came up with the fact that there is such a report. Kindly have a look at paragraph 10 at page 3. This was the prayer before the Bombay High Court. C is not relevant for us. A and B are was pressed. Now, my lord, kindly see, my lord, paragraph 29. At my lord, page 7. 29, my lord, 30, 31, 32.
আমাদের এটা থেকে ডিফারেন্স 29 থেকে পড়ুন
What the report is.
Paragraph 37, my lord should have seen it, and 45. 37 and 45.
That particular information we'll have to give. So do that. Whether any challenge was made to the Supreme Court against this?
No, no, my lord, not my lord. Not.
Why you did not cite this judgment before the?
No, I did. It is in the opening paragraph. It is noted. No,
it is not. This judgment is not there.
no, it is there. My lord. Kindly see the
page 3, internal page 3
no,
of the
no.
order.
See the judgment itself.
এখানেই আছে, sir.
Lordship, kindly see,
Takano, you referred.
and Bombay they have.
But page 2, my lord, kindly see
Yes,
that.
it is there.
Yes.
But there is no reference.
আছে, sir.
It is there, my lord. Page 2 at the.
There is no discussion on this.
My lord, learned judge was pleased to observe that it is not binding on the court.
There is nothing
Yes, there's no discussion at all, my lord. And they refer to Takano.
there.
Sir, এইখানেই বলেছি। Sir, একবার দেখবেন, এইটা দেখবেন। বোম্বে হাইকোর্ট বলছে, this is এইখানে বোম্বে হাইকোর্টের ওরা বলছে যে সুপ্রাটার বলে।
Just take your seat. Tell me about this Bombay judgment.
Para 34.
Please distinguish it.
Yes, yes. Para 34. Para 34 is the first distinction we have to make, Lordship. Lordship, the adjudication.
Same thing you are saying that you have not relied upon that report. The same thing was argued that you are not relying on that report.
No, Lordship, para 34, kindly come. There is a clear statement that on conclusion of investigation proceedings, the investigation report prepared by the investigation team and an acceptance of the same by the competent authority, the said investigation report culminate into a detailed show cause notice which is sent to noticing. So, Lordship, here we can start the matter in a two-way. One, we can go into investigation.
Come to your counterpart there in the Bombay High Court's argument at paragraph 12.
Paragraph
12 of
12.
the same judgment.
Yes. Mr. Calcutta submitted that assuming the intelligent report contained any sensitive information affecting the commercial interest of the third party, the same could always be redacted and furnished to the petitioner. However, refusing to furnish the investigation report would amount to breach of principle of natural justice, thereby denying the petition.
Their submission. Anyhow.
So, Lordship, kindly, what I'm saying is, they said that if the investigation report comprise of the show cause notice.
Please come to paragraph 16. Sorry,
Lordship,
I referred a wrong
Lordship.
paragraph. Paragraph 16 and
Mr.
17.
Desai, relying on the additional affidavit dated this, submitted that the investigation report is, in fact, the impugned show cause notice. Hence, the show cause notice itself contained the document containing the entire fact relates to the investigation. So, what he
Similarly, read.
she submitted that there is no separate investigation report as such, and the show cause notice should itself be treated as an investigation report.
17. Come.
Mr. Desai referred to the impugned show cause notice and submitted that the same contain all details. She submitted that all the relied upon document have already been furnished to the petitioner.
What you are saying.
No. She submitted that apart from this, even the non-relied document were also furnished to the petitioner. She submitted that the statement has made in the report that show cause notice would be decided on basis of the document fund.
What you are saying.
According to she submitted that there was no breach of whatsoever the principle of natural justice.
What you say. That apart from RUD, you are not going to rely any other documents. Whatever is there is disclosed in the show cause notice. Everything you wanted to say.
Lordship, here is a difference.
Non-relied document you have given an inspection.
No, there is a difference.
Now what
Lordship, that his show cause notice is, what he said is, the birthplace of the show cause notice is the investigation. Investigation I am not giving you. That was his case. And my case is,
the very first paragraph, page 95 says about intelligence was shared.
Yes.
By the Directorate General of the
Yes.
Intelligence.
Yes.
And was further developed.
Yes.
The officers of the Director General.
Yes.
Unit unit.
Lordship, let's come.
Then having they declared are engaged in such and such, which they were showing as such and such place, and therefore contravened the provision of such and such, such and such, such and
Lordship. So what is this information? Let's come. Lordship, let me explain the department's procedure. Lordship, one is we hold on someone, we started investigation. And one is, we found that there can be a evasion. Then what we do is, maybe in that case, we engage our officers to understand whether actual thing is happening or not. When he found that actual thing is happening, then we reach to the place and try to catch them. So, Lordship, this investigation is not investigation into his personal thing. Suppose we have taken a cause that all gaming will be chasing all gaming companies. So, the information I received from my Delhi office to here is also containing the third-party information.
So that is why
that's what I'm saying.
Bombay High Court says that you can give that report redacting so far as the sensitive information, because you are not supposed to disclose
third-party information
from where that's intelligence source, because that would have a cascading effect or a lot of big ramification in your functioning.
Lordship.
Because you have
many other things.
Of the informers, you do not want to disclose their identity.
Yes, even my officers.
Now,
yes. Now, Lordship, this is the difference. Now, when there will be an investigation by me,
then Bombay High Court judgments rest. To us, everything was on the same line. You cannot segregate one sentence from here, cull out one sentence from there, and then say that there lies a difference.
No, Lordship, no.
How a single judge will say that it is not binding on me as a division-based judgment of the Bombay High Court? Was there any contrary judgment of this High Court to this? Tell us.
Lordship, kindly, yes. Lordship, that is one.
The whole country, there will be a very anarchy that every High Court will think.
I'm completely with. So far as the law point is concerned, I'm completely with you. No, Lordship, kindly.
It may have persuasive value on us, may not have a binding effect.
binding on me.
On us.
Coordinate. Now, Lordship, kindly see what I am trying to say.
সময়টা নষ্ট করছে, এটা দিয়ে দিন। এটা আমার মনে হয় on the basis of Bombay.
আমাদের কোনো রিপোর্টই নেই।
Lordship, we have
Give them whatever the report, except that intelligence part. Within 2
Lordship,
days to him. And fix a date, conclude, we will record that he will not ask any adjournments.
no, Lordship, kindly see.
And it has to be concluded.
No, Lordship, what is fallen from your Lordship, kindly see.
Adjudication.
Kindly see, Lordship. Kindly let us what my learned senior friend placed. I will try to place it once. The intelligence was shared by the Director General of GST Intelligence, headquartered this, and further developed by the officer of the Director General GST Intelligence, Kolkata unit. So, Lordship, this part cannot go to him. Let's read one by one.
ইনভেস্টিগেশন রিপোর্টই নেই। এইখানে যেমন ডকুমেন্টস কি ছিল?
Lordship, kindly see, let's read the show cause notice once more, Lordship.
এটা দেখান তো যে এখানে কি কি ডকুমেন্টস ছিল? ডকুমেন্টস রিলেটিং টু স্পেসিফিক ইন্টেলিজেন্স এন্ড ইনভেস্টিগেশন রিপোর্ট। আমাদের কোনো ইনভেস্টিগেশন রিপোর্টই নেই।
If your Lordship kindly see para 10 once of the judgment, kindly see para 10 of the judgment and then my page 97. Lordship, kindly see para 10 of the judgment. The specific document they relied upon, document in the show cause, specific intelligence developed by the respondent number C and investigation report prepared by the respondent.
আমাদের কোনো ইনভেস্টিগেশন রিপোর্ট
Sir, we have no investigation report as such. Kindly see the language used, merely using investigation. Am I with Lordships?
আমাদের কোনো রিপোর্টই নেই। সাবমিশন অলসো বিন রেকর্ডেড। Council for the submitted the this is our investigation report so far.
এটা হলো বোম্বের সঙ্গে হয়ে যাচ্ছে, এটা বোম্বে বলছিল না ওটাই ওটা।
না, আমাদের তো ইনভেস্টিগেশন রিপোর্ট ওরা রেফার করেছে, এখানে আমাদের ইনভেস্টিগেশন রিপোর্টই নেই কিছু।
May I please?
Exhaust your energy.
টেনটা দেখা
I have to reserve something for the evening. Christmas Eve. Lordship, kindly come to para 10 of this judgment. The para 10 of the judgment is says specific intelligence developed.
If you go by the spirit of the judgment, then that would be beneficial to them.
True.
Because the court there invited you to give an affidavit. The affidavits were filed.
Here also, that is why the court has recorded that we have no other information report.
So then we will simply call you for an affidavit. You give an affidavit, disclose whatever you want to say, and thereafter we will decide. That will agree that we are avoiding. Now you wanted us to open the mind. We are opening the mind for that. If
But
you
let-
say that this judgment, then we will invite you to
No.
file. And till the final adjudication is made, we have to,
We are always in the hand of your Lordship.
we have.
It's a huge issue, Lordship, of the
For
country.
this-
We are in the hand of your Lordship.
For the interest of the revenue, we are avoiding this. Only thing is that when you have, why you hide it? Give it to them.
Lordship,
So that
we-
no
from
further,
the-
further argument can.
from their only document I can show it cannot be there. Let's read the language once. If your Lordship reads the language once,
Do you say that there was no report
yes, there is.
prepared by an intelligence? Please tell me, we will record that you have said that there is no such report.
Lordship, can you come to
Record. We will say the something. which is not there.
para 2 of the judgment, impugned judgment. Kindly see.
Two of the judgment what? There was a report, the intelligence report.
Lordship, I will only beseech your Lordship to read these 3 paragraphs once more in the show cause. Lordship, see, if Lordship finds, I will leave it to your Lordship. Kindly allow me. Lordship applies Lordship's mind.
Whether there is a report or there is written report, or there is no written report? Tell us. Say yes or no, we want.
It is no with regard to him.
No
With regard to him. Now, Lordship, kindly come to.
No difficulty. We are not interfering with the order. We'll say that there is no report, what the report will be.
The submission before the learned single judge was different. Kindly see at page 2.
Let them, we record. Let them
Now, Lordship, kindly come.
record.
Yes, yes.
Record.
Lordship,
No
kindly
difficulty.
come to page 96 and 97. Kindly, Lordship, read with me whether can be a report or not. Lordship,
We are saying that you are saying there is no report. We are recording that there is no report.
Lordship, specified to him there is no report as such. If your Lordship wants me, I can take a instruction from my client. It's an intelligence matter, Lordship. I have to take.
We will record
Our
your
phone. Yes, Lordship.
record you are
Under instruction, no, Lordship, my একবার জিজ্ঞেস করুন ইনভেস্টিগেশন রিপোর্ট আছে কি হ্যাঁ জিজ্ঞেস করুন Now, Lordship, till that time, Lordship, I will beseech your Lordship to look into this paragraph kindly, and then Lordship, whatever I am in hand of your Lordship, but Lordship, I need Lordship to look into that 3 paragraphs once more, and then whatever Lordship will say, I will go by that.
and will not make much more submissions.
That so I can stop right now.
Thank you. We will
If you-
go by your 3 paragraphs.
Lordship. Lordship will look into it, and after that, if Lordship thinks
3.1, we have read.
no, I will read just 2 paragraphs. Lordship, and I will pause in between reading, and I will ask myself whether this can be shared with or not.
Yes.
Yes. Intelligence was shared by the Director General of GST Intelligence Headquarters.
Where from you're reading?
Lordship, page 95. Show cause
90.
reading top,
Say
which my
97.
learned senior friend has shown.
You said 97, so I was at 97.
Yes, yes, 95. I'm sorry, my lord.
Yes.
Intelligence was shared by the Director General of GST Intelligence Headquarters, New Delhi, and was further developed by the officer of the Director General of GST Intelligence Kolkata Unit, such and such, such and such, such and such, south of this app mobile base. So, Lordship, if I go by this paragraph only, this cannot be shared with him.
You say, sir, are you please? I think either my incompetence not to expressly percolate what is passing in my mind, in our mind, or I will definitely not say the converse is true.
Probably that is
I
true,
take
but
a
then
blame on
Lordship.
myself. I am saying so, sir. Only question again. It is not a case that the sensitive information should be disclosed to them. We are against that. We will never permit or direct you to share a sensitive information to them.
True.
We are absolutely firm. We are on this issue. The other information which are not sensitive in nature, will you not disclose them?
Then Lordship, kindly see his paragraph 48 and this. Kindly see what he asks for.
That's why I say.
49. Kindly see his paragraph 48.
I have exhausted my energy.
Kindly see his paragraph 48.
I compel you to exhaust your energy.
Lordship, kindly come to paragraph 48 of his. Kindly come to para 48. Page 61, para 48. Page 61.
Yes.
Based on the show cause notice annexure there, the petitioner seeking inspection of the document sought illustrated but not limited to. Lordship, this I have satisfied them. I have given inspection. No, Lordship, I am coming.
Please. Which illustratively include but are not limited.
Not limited. Let's go by one. The document to show what intelligence was developed. Next, document to show basis of the said intelligence.
Different, anyhow.
Now, investigation report
This is
prepared
what-
its agent, officer, or any other concerned personnel.
They wanted intelligence report.
Lordship, kindly see.
What they wanted, intelligence report.
Investigation.
Like the
Sorry,
kind,
investigation report. Sorry.
no,
not
investigation report by
They wanted.
Investigation prepared by
Correct.
DGA.
They
If they-
wanted, I think, if I am not wrong, you wanted it.
Document relied upon this, so Lordship,
Definitely.
4 I have complied, 5 I have complied.
Now question is there any investigation report or not? Yes.
Under instruction, there is no instruction.
That's all we are recording.
So Lordship, so regard to 1 and 2, he is not entitled to.
The Bombay judgment also, so far as the interdepartmental communication, the Bombay High Court has also discarded that you are not
So
entitled.
only 3 is the investigation report
That's all.
prepared by
We are
DGA.
concerned with this. No difficulty.
We don't. Under instruction of my advocate on record, I am saying so.
That's all.
Kindly see what is observed in Learned Single Judgment, page 2,
Sorry, we will not.
paragraph 3.
We will say not
The-
sensitive.
The submission is that
We will record. We'll record. What is the difficulty?
But may that be 10 days, no, it'll just take us beyond that first.
Only 25th is a holiday, 26th, 27th, 29th, 30th, open. 31st, you may have some other jubilation I do not want, or don't. Will not, younger generation.
I convey my New Year greetings to both of my
We reciprocate the same to all of.
receive. Receive.
Yes. For the next.
Serial number 7.
1785.
Seven, I am for the response numbers 1 to 5.
Not.
Serial number 8.
I am for the response number 1.
This is the appeal filed by the KMDA, my lord. But the impugned order is at page number 283 of the stay application. My lord, in the writ petition,
This is an urgency, can it not?
my lord, we did not mention it, my lord.
Not today.
Serial number 9. Serial number 10.
My lord, in item number 9, my lord, I am appealing on behalf of my lord the appellant. My lord, on the last occasion, my lord, we were directed to file.
Lord, I am
affidavit in
Is
reply.
it very urgent?
No, my lord, we take some time, my lord, to file the affidavit in reply, my lord.
Whatever, then not today.
Much
In the
obliged.
meantime, prepare.
But I have filed my
If
opposition.
it is very urgent, then.
Last
otherwise,
occasion I have filed already.
Yes, call the next 10.
Serial number 10.
I am for the my lord appeal.
Is it very urgent that it
My
cannot
lord,
be?
yes, my lord, the 17 is date fixed for.
So on, second of, no difficulty. Not.
Serial number 11. Serial number 12. Serial number 12. Serial number 13.
Lord 13, my lord, I am appealing for the appellant petitioner.
Is it very urgent?
Sorry, my lord, I am sorry, my lord, 14, my lord.
Serial number 14.
Same
My
question.
lord, I am, my lord, for the appellant
Same
petitioner.
question.
My lord, the urgency is involved. My lord, we are apprehending a sale notice being issued.
Till reopening,
Reopening, my lord.
2nd of
My
January.
lord, we are apprehending a sale notice, my lord. We are under an order.
Whatever.
My lord,
Sale will not be conducted during the week.
no, my lord, that is.
So second,
My lord, let it, my lord, remain in the position.
retain its position, second.
I am grateful to your lordship.
Serial number 15. 16.
For respondent number 6.
Appellant,
Appellant item number 16, Your Lordship. Your Lordship, I am led by Mr. Shomu Majumdar, Your Lordship. Kindly
What?
pass over.
then Passover is then after, not.
Serial number 17.
Your Lordship, I am appearing for the appellant, Your Lordship, in this
I am
matter.
for respondent.
Application, we are taking up normally, move it.
Your Lordship.
17. You
No,
say 16, 17, grant a leave, now you move it.
Your
We have
Lordship.
reached.
16 and 17.
I am for respondent number 4 to 11.
Thank you, madam. Have patience. What is the matter about?
Your Lordship, my senior.
17. 16 and 17. Are you there in the
Lord, I
matter?
appear for the.
Can answer.
Which matter is that?
16.
The order which has been complained of, Lord, has been complied with.
Have a right to, let us see. They were mentioning that they wanted to move in the vacation. We said, why you underestimate the pace of the court? Can't be not reach 17 today. No pen is filed.
Your Lordship, can has been filed. It was filed on 17th of December, Your Lordship. I had taken leave on 16th and had filed this is the filing receipt.
But there is no application that has come before us.
Your Lordship, this was filed in this court itself, Your Lordship.
What can be done? This can't be filed. Can't be there in a central filing section. Application টা দেখো এখানে এসছে না ওখানে গেছে না আনাও 17 কি আছে দেখি
Your Lordship, item 17 may be taken up then.
Of 17. Yes, 17. Can have come.
Your Lordship, it is item 16 or 17?
17.
Your Lordship, items 17, page number 26.
Why two application stay of the operation of the order, stay of the operation of the order? Hey. একটা মোটা
Your Lordship, one is section 5 application for abundant caution. I had filed the section 5 application. Your Lordship, because I'm challenging the orders. There are 3 orders under challenge. 20. The last order is 13th of December, Your Lordship, which is the main order by which there has been a direction, Your Lordship. The parent order is at Your Lordship at page.
What is the date of the parent's order?
Your Lordship, parent order is 28th of November 2023, which is at page.
And you are challenging without the certified copy, then the
Your Lordship, I'm not challenging the parent order, Your Lordship. I'm challenging the order passed in contempt, which is on 13th of December 2024.
was the 13th of December.
Your Lordship, the 13th of December order is at page 35.
Can one?
Your Lordship, can one. Item 17 आगे move
Let us judgment बोले दिए चलेगा कि भाई बोलते first. The first.
Your Lordship, my learned
Whether the appeal lies in view of a very recent judgment of the Supreme Court. If it is a case of a punishment, I can understand the appeal lies. But if it is not, then the Supreme Court very recently has held no right of appeal.
That's a statutory right.
No, statutory right. That was an interpretation. I think section 19 of the Contempt of Courts Act was interpreted. Our special bench was of the view that it lies. But recently, just last week, the apex court has said that no, if it is a dismissal, no appeal lies.
It's not really.
The Supreme Court judgment is binding on
it's
us.
really not modified. It's really in the nature of a letters patent and not a statutory appeal within the.
That is what is a statutory.
Please.
Contempt. In a contempt.
Not that old principle in Himji's case.
Himji was also considered. Himji says that the one which does not come within the purview of a judgment, letters patent clause 15 appeal does not lie. That's the Himji's case. Here, section 19. Section 19 was interpreted in that way.
Section 19, not of course, not only if punishment is imposed.
That is what was interpreted. Our special bench, I think Mr. Parthasarathi Sengupta argues in that matter, it was held that even a dismissal of the contempt application gives a right upon a person who have initiated the contempt to file an appeal.
That was negated, not in the sense that
now
the section is from a penalty order, but not in a case where the court has modified the order.
Was that now the Supreme Court has said no appeal.
But here we don't seek an appeal not from an order of punishment or dismissal of a contempt.
No, rejection of a contempt. The rule is discharged.
But the order
said that we are really challenging the order of 13th of December.
But 3 orders are under challenge really.
No, 13th of December she says, and by which we find that it is a discharge. So
please come to page 35 once.
Dismiss.
Please come to page 35 once.
Look at it.
Has filed a report. Certificate officer has filed a report, which is taken on record. It appears that there is no stay on the disbursement by the certificate officer. The Registrar General of the court shall comply with the request of the certificate officer for transmission of funds as expeditiously as possible, preferably within a period of 10 days. Nothing further remains to be adjudicated in the contempt applications.
Now, again, I'm saying that what?
That the court has really modified the principal order.
Equitable question now originating from a contempt. If there is a right of appeal provided in a special statute and a right of appeal provided in a general statute, then the special statute will definitely prevail. Generally, as case, I do not know, I can't pronounce that legal maxim or a.
The general must yield to the special.
Huh?
The general must yield to the special.
Reverse is also true. So what can be done? You satisfy that first the appeal is
Not the scope of the appeal that is really not in the nature of section 19.
To say that if while exercising the contempt jurisdiction, the court cannot vary the parent order. I understand. So what do you think?
That's the sole point.
I understand. But the problem is, if you have approached the wrong forum, then what can be done? You may have a best point. But if you approach the wrong forum, what can be done?
After
Show us.
পয়সা রিলিজ হয়ে যাবে তো এবার পেজ 64 টা প্যারেন্ট অর্ডার আছে দেখান পয়সা তো নেই বলছে রিলিজ করে দেবে 10 দিন হয়ে গেছে তার থেকে
Please come to not two orders.
Orders we appreciate it. Again, I am saying, first is the competence of the court. The competence is a foundation. It strikes at the root of the jurisdiction.
Right.
If we do not have a jurisdiction, even if you are the best case on law, can court exercise.
irrespective of jurisdiction.
Don't listen to her. Apply your own independent.
No, I haven't gone through that judgment, but I shall.
Please go.
There has to be some way out.
Please,
Can't be that.
That's why I'm saying this is the problem. This is the problem. Come after vacation.
Not some observation as regards the disbursement.
Cards there.
Observation, not an order.
What observation?
I tell you, Lordship, what the difficulty is.
I understand. But
The certificate officer writing to the Registrar General of this court for release.
Yes, that's the order of the court. Court has given him liberty.
A collector writing to the Registrar General of this court for release.
No, not release, because that is the order of the court, as per order of the court. A request.
There has to be some maintenance of hierarchy at least.
Court shall comply with request of this certificate.
Appreciate every
Yes.
bit of your argument, but
As per order, bolchi to request.
There is a subsequent order.
The subsequent order, you have challenged that order.
but primarily I am.
Yes.
Has to be not some way out.
Prima facie not inclined.
Can't be that
The query is raised to the
My lord, mention a matter for inclusion in the monthly list of January.
Come in the month of January. Why last date?
Under compelling circumstances, my lord, may I mention one matter, my lord? It was taken up by your lordships on, my lord, 18th, and my lord, considering the urgency, it's a new the application, my lord. Considering the urgency, my lord, your lordships are pleased to, my lord, give direction so that it appears today. It's not appearing today. My lord, can it appear on, my lord, any day, 3rd or, my lord?
Reopening at the end of 2nd.
That would be in the monthly list, my lord. That is. Well, I shall give you.
Your list is the list. Hey, monthly list हो गया वो ये दाओ
Lordship, I am obliged.
Specially fixed matter बोले.
I am obliged.
Let's call.
Item number 1 for judgment.
Sorry, appeal is dismissed.
Item number 2. Item number 3.
We can't help you out. We tried, but could not extend anything.
Appeal is dismissed.
Item number 3, my lord.
Dismissed.
I'm grateful, my lord.
To mention item number 4.
Why did you mention? Oh, yes. This matter was argued, so but we wanted certain more clarification, and a lot of time has gone. So we have to fix this matter again when all of you are ready to argue.
Second week of January or second week of January.
Why? A week. Why not 2nd of January?
For the central business.
2nd January.
Then next week, if possible, after 6th any day, if possible.
7th.
So
7th.
7th. Let this matter be listed for on 7th January. Or for.
yeah, for that.
Yes, we also wanted this to be listed.
I am for the respondent number 4 and 5.
7.
For further hearing.
For the
On
any day. 8.
Hmm.
It's for further hearing.
8. 8 तारीख. Item number 6.
Find out what's happening. And find it.
So there is no application which is filed. Only the memo is filed.
The entire appeal is.
With the HO. So আমার কাছে তো তুমি পাঠাও নি.
Entire appeal has been filed, Your Lordship.
Now the point is which troubles us.
Please.
We have seen the nature of the order. We have seen the nature of the order.
The next order is also already uploaded.
Yes. Now tell me whether it comes within the purview of judgment under clause 15 of the legislative.
Lordship. My interim prayer was refused by the learned single judge. Kindly appreciate what is the case. Just give me 5 minutes.
Yes.
The impugn order of the Government of India was passed on 26th November. It is a case of increase of seats.
Follow. Where is the impugned order of the government?
Government of India order. Now kindly see, Your Lordship.
Central government.
That is at page 97. Complete non-application of mind without appreciating what is the facts of the case. Kindly see.
Just
Please.
एक कोणता पाठ सांग बोलले? 4 नंबर पाठ काय?
बताओ ना तो पेज नंबर नहीं बताओ मेरे पास फाइल नहीं है क्या? देख ले
এখানে লিখে এটা দেখে নতুন কত টাকার অর্ডার আছে
Yes.
Now, on the two grounds, they have declined my permission, which is a fresh permission for an additional 50 seats.
Yes.
The first is that they are saying that the attendance for particular 2 months, 3 months, short for 20% of the faculty. They are not saying it is not there, the faculty is not there. Simply attendance like 75%. This point has already been overruled by themselves in granting permission to other colleges. I will demonstrate from the order which is on record. Why they have given, why I have not been given. Why there's discrimination. Second is faculty. They are saying that my 57 faculties are short. What was the reason given? That I have appointed faculty. This is an ongoing process. It is a scheme when you submit an application, which was submitted last year in September. The process is that they will, after analyzing the application, will give me the show cause. MAV will send me the show cause, pointing out the deficiencies, which I have to remove. That is as per the Act. Kindly see the Act, what the Act says. What they did, MAV has not assessed my application. This is the only difficulty in this case is for almost 6 months, they were sitting tight on my application. First decision came on 4th April, saying what? No, last year you got, we will not give you this year. Where is that regulation? Let my friend show that is written in the Regulation Act that if I have been given permission last year, this year I will not be given. Why other colleges have been given then? IQCT got permission this year after the court order which I have given. Last year, they got 50 increase. There are other colleges across the country. Entire list is with me. I'll show your lordship what they did. In this case, if you see, what is the finding at page 103? Aforementioned information clearly shows that a total 57 faculty was appointed after getting disapproval from the MAV MLC. Please.
Disapproval, after disapproval, recently. Two things. That these 57 faculty members were appointed after the disapproval was communicated to you?
No, that is what I am trying to show.
And they have been appointed very recently.
No, this is again wrong. That is what I am trying to demonstrate. This finding itself goes. Kindly see the dates of the appointments. If you see the chart, very relevant. Very first appointment, if you see, somewhere appointed in January, somewhere in February, somewhere in March. What is the date of the first decision of the NMC? In August. Kindly see the decision. First decision of the MAV is in April, simply saying that we will not entertain. They are not saying that your faculty is new. They are not raising this objection. Simply saying, kindly see the order of the MAV. That is very relevant. Only reason given, 50 last year given, this year will not entertain. They are not saying that faculty is new. Who is the statutory authority? That is the authority which will decide whether faculty is new or wrong. Every year, numbers of professors leave, come. This is an ongoing process till the time. This is very important. Till the time you have to submit your assessment. The college is assessed every year for granting the permission. This is under the Act, under the regulation. So what they did, I got the opportunity only when I went to court. Court directed them, then how you will not entertain their application? Where is that regulation? They said, no, there is nothing so they allowed me. And after the court direction, they allowed me to submit this assessment form, which was submitted on 30th September 2024. So that will be the cutoff date. That will be the cutoff date for seeing my faculty, because that day you assess the college. Then you decide what are the deficiencies, which is being communicated. So in this case, this was never done. On 30th September, when I submitted, I had got 163 faculty, which was registered on ABAS. Once it is registered, it will not be shown across the country in any college. That will be counted as my faculty. This is what the regulation says. So what they did, that SAS, if you see 163, so requirement is 168. So I'm less than 5%. Less than 5%, their own regulation. They have given permission. They say in the order, I'll show from the record that I've annexed that regulation which says that if the college is having less than private college 5%, up to 5%, I am allowed for that year. Mine is 4.26 on that day. Subsequently, when hearing took place for the first time before the NMC on 11th October, what they did, they sent me the email immediately. During the course of the hearing, the appellate authority, first appellate authority, which is NMC, which is the body to decide, they asked me to give me the faculty list, which was submitted. Kindly see that faculty list at page 450. On that day, volume 2, Your Lordship. And email was also sent. Kindly first see the email, page 447. Very important. Why they are asking me to give the faculty list? Because they are counting that faculty. That is why it is being asked. Otherwise, why they will ask me? How can a government of India will come with the new defects showing at the age of second appellate stage? It can't be. They have to pass the order on the basis of what they have. The finding has been given by the statutory authority. How can they do that?
Yes, it is saying the details of the available faculty members. Then
we submitted on their email on the basis of on that day. What was my faculty? Kindly see page 450, second volume. Please. This is the entire list, annexure 318. Kindly come to page 451. This is accepted by them. It is not that they have not accepted this, because no finding has been given by the statutory authority that these faculties will not be counted. Designation, Professor 20, actually available as per Abbas 26. So it is surplus 6 on that day. Associate Professor 62, 55. So how much less? Only 7. Assistant Professor 86, 82, 4. So the total requirement is 168. We are having 163 as per UG MSR 2023, which was the regulation. This year they have accepted, on the basis of which the permission has to be granted for 250 seats. So I am seeking increase of from 200 to 250. So only 50 increase, which is a new permission. You cannot correlate with the old one. Now it says 97% is available. Only 2.98. Here it was only 2.98. Now designation further available. This requirement as per 23 is 3.25 deficiency. So kindly see now the circular regulation of the NMC. What says 5%? I'll show, and the judgment also of the court, which has allowed this. And they filed the affidavit in the court.
I find this earlier round of litigation was in relation to some other college or your college?
No, earlier round of litigation when I went to Delhi High Court for what? Directing them to allow my assessment to be done of the college. I was telling them to assess my college for this year, which they were not doing.
So you went to a Delhi High Court and the Delhi High Court entertained it. Now you are coming to a...
No, why I am coming? I'll tell you, Lordship, what happened. 27th September, Delhi High Court directed them to assess my application. Even Government of India in their first order has told them to assess my application. Forget about Delhi High Court.
That is what we find.
Pardon?
That is what we find. But I was just harping that...
Why I'm saying? So Delhi High Court, what happened?
The Delhi High Court, then why do you want to approach
the
Calcutta High Court now?
Delhi High Court said that due to so many petitions were being filed, so the learned judge, before which we are appearing, he said that I will not entertain on the jurisdictional ground. Kindly go to your parent High Court, because otherwise everybody from across this country will come to Delhi saying that since office is in Delhi, so jurisdiction will be there. So we said, okay, fine. So he allowed us to withdraw to approach this honorable court.
That is what we really wanted.
Yes, I'll show that order.
From there.
Pardon?
You were permitted to withdraw.
Yes. This is the detailed order of the Delhi High Court. So all the petitions in Delhi High Court that day, I was appearing, 9 petitions were there. All were withdrawn and subsequently they went to this court. One of the college, Mandakini, also came to this court. And he got the relief from your lordship. They set aside the order of, by the Ranne Singhal, they set aside the order of Mandakini Medical College and sent him back to the Government of India in 2 days to decide fresh. Kindly see last page. In view of the aforesaid position, that is at paragraph 4 of the last page.
I've seen that.
So this was the only difficulty. Otherwise, I've got the relief there only. Because already one college got the relief, I2 City, on the similar identical facts. Their application also, they said, Maharb and NMC, that no, last year you got, we will not increase. Now finally he got the increase. He has taken the admission. Why I am coming before your lordship?
Did not disclose all those facts before the single page.
I have disclosed. Kindly see my writ petition. Everything is written. Kindly see.
At the time of moving, did you brought to the notice of the single page that these are the developments which
Yes, each and every submission was made. I told why the same question was asked by the learned single judge. He said, well, Mr. Bhasin, when you're in High Court, Humble Lordship, don't give 2 weeks time. Otherwise, I'll be out of the race this year. Normally in Delhi, we got 3-4 days to file the reply. So, well, the office is in Delhi, so it is very easy to give in 3 days. So I will give 2 weeks. Humble, fine enough. Despite my repeated request, I said, at least give me interim protection. Let the authorities, because that time the counseling was going on. This is very important. That time the counseling was going on. I filed the writ petition in 1 day before this court. Next day, the court was only when the matter was listed. So it came on 2nd. Still the counseling was going on, the last round, which was up to 5th December. That day, court, I literally begged the court that day. My learned friend was not there on that day. The other counsel was assisting, he was engaged on the next date, on the 20th. Now, simpliciter order is being passed, again 10 days. So what is the purpose? Where I'll get this? This is the case where complete violation of my Article 40. And I'll demonstrate what order they have passed. Kindly see. If you are saying my faculty is appointed after Maharb and NMC decision, then you have yourself been mentioning the dates on the right-hand side column. January, February, March, April, May, where is that decision? Your decision came for the first time on 15th October 2024, where the appellate authority, which is the statutory body, final authority said, no, we will not give you. Why? Can you see the reasons? What absurd reasons has been given? Yes. Can you see that order? The first appellate authority order, 1510 page 94-96. 94-90. Now, can you see that order, please?
Oh, that is what we 94.
94. This is the first order. Earlier, there was no order in my case. Where is that order? This is the only detailed order where the appellate authority chairman is sitting of the NMC. Other members are sitting to hear my case. Only when I submitted my assessment form. So you have to see the faculty on the date of assessment. This is what the law says. This is what the regulation says. This is what is being followed across the country. Otherwise, no college will get the permission then. How will you judge whether he is having the faculty or not? Only on the date of assessment. So my assessment was on 30th September, not prior to that. How can they give this list? What funding the government of India is giving? From where this finding is, they've got, whether the statutory authority has given this finding, that I have got 57 new faculty. Does the second appellate authority will come with the new finding saying that, no, we will not give because you have this faculty? What opportunity has been given to me to rectify that deficiency then? That is why they asked the list on 11th. Kindly see the email. This is very important. NMC will decide what the email is being given.
What is the outcome of the counseling? What is the
counseling? What happened now? What happened? When I was before the... No, kindly see that order is on record. Kindly see Supreme Court order, page 627. No. Now see what I am. That is why I am before your lordship. I am begging before your lordship. Why? They have given us the opportunity once again, which is the stray round counseling, because thousands of students are waiting to become doctor.
I believe really seriously looking into the matter where are filled.
Why? That is also reason. That has to be understood. Why? Please. That I know. Everything is there. This is now this round is called stray round. That is why it is called, the stray word is given. How the country needs the doctor. This is what the observation of the court is. Yes. No, that was That too, why? That too coming before this court. They again, that last year also they did the same story. I got the relief from your lordships only. And they went to Supreme Court. Now, kindly see, they went to Supreme Court and their petition was thrown when I got the increase last year.
My lord will kindly appreciate one thing. First of all, my lord, it's falling that I should answer only on that particular point which has fallen from my lord. My lord, there are various issues. No, my lord, we have never said that. No, my lord, that is not the case, my lord. First of all, my lord, first. No, my lord, my lord, the first thing, my lord, first thing, my lord, that particular order in which this particular finding was there was set aside by the second appellate court, remanded back. Then the order was passed, which is at page 94, which is a very reasoned order. Then subsequently thereto an appeal was preferred from that order, which is now again impugned before your lordships, which is at page 97, which my lord had read. Now, my lord, what I am humbly submitting, my lord, here is a case, my lord, where first of all, whether, my lord, again, my lord, I bow down to what had fallen from my lord, whether this appeal lies, first point. Second is, my lord, that at interlocutory stage, can final relief be granted?
Yes.
Two.
I'll show the judgments there.
Two. My lord, without even calling for an affidavit, that also when a matter has been decided in second appeal. Two. Thirdly, my lord, the points which have been pleaded by them, rather forwarded here by way of submission. That, my lord, when the faculty was appointed, my lord, the first order was passed. The first order, when the order was set aside, was passed way back, if my lord kindly sees, that order which was set aside was, my lord, on 29/5/2024. And, my lord, the appointment of faculty, most of them have been made after 29/5/2024. Now, my lord, in second appeal, our contention is that when in the first appeal, first round, it was not a reasoned order. My lord, and my lord, as of now, my lord, as far as the Honorable Supreme Court is concerned, my lord, the order which is before my lord regarding counselling, that is with regard to what? The seats which are already available with the college. Here they have no seats. What about counselling? My lord, I apologize, my lord, but if I am unable to understand what has fallen from my lord, there is no seat. I apologize. Yes, lordship.
That means that the seat which has already been scratched by the
Yes. I'm grateful, my lord.
the case where they wanted it as well.
I'm grateful.
The enhancement is granted. Then this seat is also
Yes.
Yes, my lord. Yes, my
Yes.
lord. Yes, my lord.
that category.
Yes.
Unfilled seat.
Yes.
I'm grateful to my lord.
Yes.
I'm grateful, my lord.
Yes.
I'm grateful, my lord.
Yeah. The question is again that what was there not law, which is assigned while because if you have given or provided a statutory right of security, so as on the date when the is decided, if it appears that the deficiency which is was there existence in existence, exactly that we cannot take that particular thing out of the custody. Now, so your the shortfall or the deficiency number of the infrastructurally say that you are not going to.
Yes.
But I find there is another thing. 8 lakh the penalty was imposed.
No, 6 lakhs, your lordship. In this case, 6 lakhs. Now that is very important. Their argument was this before the learned single judge. This was the only argument put on that day. Yes, kindly see what is that, please.
That is there. There may be
My lord,
already paid.
may I very humbly answer to my what has fallen from my lord? My lord will kindly come to 103 page, the order. My lord will kindly come to the last bullet point. The committee, may I allow, the committee further opined that contention of the institute to consider deficiency of faculty in totality and department-wise not hold ground, as the MRC has framed department-wise and faculty of one department can. That is what we are saying. My lord, that is what we wanted to file by way of affidavit. Prima facie.
No.
My lord, where? Yes, my lord. My lord, MSR is
Yes, the medical standard regulation, which is issued by the NMC from time to time. This year, what they did, they issued in 2023 the standard regulation for the colleges to follow. If you see the MSR, I show from the record. Yes, I'll give the reply. Should not be counted on a total basis. That is to be done. This is what the MSR says. MSR
my lord will kindly, what I'm humbly submitting before my lord. Here, my lord, what happened before the honorable.
Yes.
Before, my lord, before that, my lord, may I make one submission, my lord? Here, what is the order imputed?
Come to 605 for a moment.
Sir, मुझे बोल देने.
MSR का page, they are asking for the page.
ठीक.
I am assisting you, brother.
No. There is
605.
nothing against
MSR
you.
is the page.
Nothing against you, sir.
This is what the Lordship wants to see. Volume 2, your Lordship, 605. Where does this regulation says that it has to be seen department-wise, otherwise in the entire country? Kindly see 605. Yes, kindly see at the bottom. Total strength of the faculty is to be seen. What is the requirement for 250? 20 professors, I have 26.
Kindly see 603. But I have not paid anything till now. Kindly see 603.
Yes.
Because department-wise, every post is mentioned.
No, that is true.
Faculty requirement, kindly see from now. 1 minute.
My lord, 60.
I am not.
My lord, we have not. My lord, we have not, my lord. Yesterday evening sent. This,
I bowed out.
my lord, the same is with us, my lord.
I was there. One page order. Kindly consider this aspect. He is seeking an interim order. Now, what is the interim order? Yes. By interim order, you will get.
That's 60. Page 1 is 60.
Sir, what you are 605, what you are showing this? Sir, the scenes are showing this. Okay.
अभी हम वो भी दिखाएंगे. हम डिपार्टमेंट वाइज भी दिखाएंगे. Don't worry. आपका दिखाओ लास्ट पेज जहाँ फोटो देखता है. Yes. Now, Lordship, my learned friend is now.
My lord, my point, as far as now I decided, my lord, my point is what interim relief. My lord will kindly see the writ petition. They are wanting final relief at page. My lord will kindly come to page 91. In fact, it starts from page 90 of my lord's brief. The interim relief in the writ petition. The relief in the writ petition. Volume 1, Volume 1, page 90. It starts from page 91. Now, will kindly allow me. B, issue writ in the nature of mandamus or such other appropriate writs or directions to the respondent number 1 to 3 to issue letter of permission to the petitioner for increase of seats of the petitioner MBBS UGC from 200 to 250 for the academic year 24-25. Then quash and set aside the impugned order dated 15/10/2024. That is by the MNC. Then quash then set aside the impugned order of 22/11/2024 passed by the respondent number 1 UOI. Then issue writ in the nature of mandamus or such other appropriate writ or writs to the respondent directing them to add into the seat matrix for the counseling process for the year 24-25, the seat capacity of 250 for the petitioner medical college and forthwith conduct counseling for admission of additional 50 students, total 250 students in UG MBBS program, Petitioners Institute for the present academic year 24-25. Issue writ in the nature of mandamus or such other appropriate 50 seats. Now, will kindly come to the interim. I, 92I. Add interim order in terms of prayer B, C, D, and E. Now, B is what, B is increase.
This is what I'm asking from the court.
Then add interim stage. Then, C, that is quashing of 15/10/2024 order without giving anybody a chance of hearing. Then, एक second, sir. D is quashing of the order of second appeal. And E, the counseling. So everything has been asked as an ad interim relief, rather interim relief.
Just prior to this, I have said that there is no absolute bar in the court granting the interim.
Please.
On the ground that it will tantamount to granting
your final relief. Yes, Your Lordship. Please.
Even I give an example that if it is a suit or a then the temporary injunction can be granted since past. I have said that in that case, opportunity has to be given to the other side.
Yes.
And
Yes.
after that opportunity,
But that opportunity should be endless.
can added stake. Yes. Court can the court at the added stake
Yes.
really tantamount of granting final.
Yes. Why I'm saying so?
We say that you immediately increase the seat by 50% to 50. That means implied order of the second appellate authority goes.
Yes.
So at the interim stage, you will really set aside everything.
Why? Kindly see what opportunity has been given in these such type of cases. What happens? The time schedule. Let me, Lordship, kindly appreciate. Kindly see the opportunities. Kindly see the opportunities. You got, Lordship, I will show the opportunities.
Counseling is over at 11.
18 days time given, you are not filing reply. Why?
My lord, initial counseling was over when the matter was heard for the first time.
No, that I will show from the record then. Again, my learned friend is giving the wrong statement. That is why I am before this court. Lordship, my learned friend has raised two objections.
My lord, I have not completed.
Acha,
my
you're
lord.
I thought
Well, certain things had fallen from your lordships regarding, regarding certain things had fallen. So I was trying to make my submissions as far as those points are concerned. You know, the first thing which was fallen from my lord, that at interlocutory stage, the discussion, my lord, I'm just giving my lord a recapitulation. What was falling from my lord before we went for recess was, no, but I'm not on the. I'm just giving recapitulation as to where the argument was. My lord. I'm just on that. My submission and what was falling. So, my lord, what my. I know, my lord. Elephant's memory. Elephant's memory, my lord. I know, my lord. But yes, that's the right term. That's the right term. So, my lord, what I'm humbly submitting is, my lord, that, my lord, Dada, judgment I will give you the better. Now, my lord, interim relief granted, my lord, at the final relief granted at the rate at the stage of interlocutory. Now, my lord, that urgency should be pleaded. What is the urgency pleaded? If my lord kindly comes to page writ petition, page 89, my lord, of my lord's brief, lordship's brief, page 89. Last paragraph of page 89, 69 paragraph, my lord. May I read, my lord? It is submitted that there is grave urgency in the adjudication of the present writ. My lord? No, my lord, I'm yes, my lord. Now, my lord, the matter first came for, my lord, just for my satisfaction, I was trying to read. I'm never saying that my lord is slow in reading the entire paragraph, my lord. I was just trying to place it before my lord for my satisfaction. Now, my lord, we'll kindly see fifth of. No, my lord, what I'm trying to impress upon my lord very humbly is that the urgency for granting interim relief was pleaded. That urgency is going to expire on 5/12/2024. The matter was taken up on the 22nd. The order which is again impugned before my lord. Order of 2nd of December and 20th of December. That day when the order was passed for giving time for us to file a report, this appeal was not preferred. And they allowed this urgency to fade out.
That is why the
and I am on a different aspect, my lord, that why interim relief, as it had fallen, my lord, that if there is a grave urgency, they allowed there, and today also the counseling is over, what I have been told, at 11.
Kindly see the schedule.
My lord, I'm not on that, my lord, what I'm humbly submitting. My lord, what I'm saying is, my lord, I'm trying to amplify my argument on that particular quotient where I said that what interim relief they have prayed for. They are wanting set-asiding of the entire order passed by the Union of India and by the MNC, which is a reasoned order. And, my lord, the grounds which they are saying is that those faculties were available, my lord, in my respectful submission, on the date when it was considered and rejected by the concerned authority. This faculty was not there. That was as back as 3rd of April 2024 as per their own list of date. The first order which said that faculty-wise it has not been decided and you don't have faculty, requisite number. That order was passed on 3rd of April 2024, where admittedly they did not have. Because in our order, passed by the Union of India, we have categorically said that when those appointments were made, and if categorically those dates are tallied with 3/4/2024, my lord will kindly find that they did not have adequate. Now what they are trying to say, that when the matter was set aside by the second appellate court and send it to MNC for reconsider, that is the date when it should be considered that my faculty was proper, prim and adequate or not. My lord, the law in my respectful submission is when you make an application. Yes, Philip. Yes, Philip. Yes, Philip. Well, well. Yes, Willard.
In this regard, that from the day of the institution of the report will take it account whether the
Lisbon, Willard. Lisbon, I stand corrected. I stand corrected.
on that day, what is there? Because you have secretary, so you have to justify. I've just
यार तो बीच में बोल रहे हैं
report in MSP. You know the MSP judgment.
yes I've got that कौन आया
For the first time,
मैंने के मांग रहे हैं तो क्या दे रहा है शौकीन
no, there is an exception. Don't say. There is an exception when copying there in the behalf.
yes
Department of any other pre-agreement report. I am conscious of those. You can't do that. Plus, that this frigate team should be considered on a subject-wise basis. Not their condition is no. According to this, you have the number of the and you can't segregate or compartmentalize those on a subject matter or a department. This is where I find there is a disagreement. Authority has said no. They say no. If the total number exceeds, then you cannot say that there is a deficit. And according to the law, there are certain subjects in three departments say that there is a shortfall, and which really is considerable shortfall. 6%, more than that. This is what you understand. The first and foremost point that it requires to be counted or segregation as you have. Where is that page?
Your Lordship, that is in the impugn order itself. It is mentioned.
No, that it is at page 403, 603.
603.
Manu, the faculty also is given apropos the number of seats. Yes, sir. Yes, Professor Willard.
This much of
Yes, sir. In each and every department for the number of seats. If my lord kindly allows me. Is 250, my lord? If
yes.
No, my lord.
Next page.
Yes. Total number we have given, but then that we have. It is to be written.
Yes.
Because this is not document, we cannot.
No, I am not going beyond it.
The interpretation that's been done.
Yes, my lord.
on the basis of a subsidy or
Milord, very respectfully, may I submit, Milord? This is an expert body, Milord. We are the people, Milord. Now, Milord, a person, first of all, my submission is, Milord, that, Milord, first is maintainable.
Yes, I have, Your Lordship. Yeah, I'm having this. Yes, Your Lordship, I'll refer to paragraph 21 to 28. And Lordship is referring to paragraph 15, 115. Please.
Citation दीजिए
आपको दें
बिल्कुल दे दीजिए हम कम पढ़ेंगे
प्लीज 4 SCC 1981 page 8.
My Lord, the director has to read 117.
170. Let us take another instance of similar order which may not amount to judgment.
My Lord.
Please. Let us take another instance of a similar order which may not amount to judgment. Suppose the trial court allows the plaintiff to amend the plaint by adding particular relief, taking additional ground, which may interest the police taken him, but is barred by limitation, does not work serious injustice to the defendant. That is what because Your Lordship, so my humble submission will be on that. No, Lordship, kindly appreciate. This case itself requires the time constraint was there, which was explained to the court. We are before the court for what? We are seeking the setting aside of the order, which is completely erroneous, and I will show why. Give me 5 minutes and I will demonstrate that what order they have passed in my college and what order they have passed in granting permission to other colleges. Why this discrimination? Yes, kindly see one college first, PA Sangma. And then I'll come to that point. No, kindly see PA Sangma, page 553. It is a private college who applied for 150 seats. Now kindly see the deficiency. Both answers Your Lordship will get in that order. 53. By them only. 30th August order. Kindly see what is the order. 553, Lordship, come to 554 straight away and see the deficiencies. First appellate authority deficiencies at the bottom. OPD attendance, faculty deficiency at the level of professor, dermatology 1, FMT 1, microbiology 1, orthopedics 1, psychiatry 1. Faculty deficiency at the level of biochemistry 2, surgery 2, ophthalmology. So these are the departments. So the Lordship's question was first that how can you explain the department-wise deficiency? If it is department-wise deficiency, then what is the requirement of this particular department for 150? Only 9, not even 9. 8 professors, associates, and combined 8 only is required. They are deficient. How much, for example, biochemistry? 2. Then what will be the percentage of 8? How much? 25%. So each college will go then. Not a single college will get permission if this is to be seen as a department-wise. It has to be seen in totality. Otherwise, what will happen? Suppose I have a 9 in anatomy requirement as per their MSR guideline, which comprises of professor, associate, and assistant. I am having at present 6. So 3 has gone short. That means it is 66%. So 66%, then I will never get the permission to run a college. So no college will get permission because each and every college has 1, 2, 3 associate assistant shortage at the time while seeking the permission. So that is why totality has to be seen. Their own assessment form, which is given by them, which is seen by them, the assessors. Kindly come to next page. I'll show PA Sangma order. What is the finding given by the order passed? Kindly come to 555. What is the observation given by this appellate authority? The college in its second appeal. This is very relevant, Your Lordship. 16 faculty short at the time of hearing of the second appeal. That is in the month of August. The assessment was done in the month of March, April, as per my learned friend submission. So if it is in March, April, that means there was no faculty. The faculty which they appointed on 28th August, after the NMC decision, after the MAP decision, at the stage of second appeal, why are you giving permission to them then? Because their shortage is more than 5%. Kindly see their shortage. According to this, it will be, please. Yes. As per NMC norms, the requirement is 150 seats, 19 so and so. Colleges are having 121. Yes, this is what I was trying to show Your Lordship. Otherwise, no college will get permission. Lordship has rightly held this. This is the discrimination. I will show another order. Now, another order. Kindly come to the Satya Sai. These are the private colleges you are giving. Forget about the government colleges. And Lordship, not only this, kindly see. What the percentage? No, first Your Lordship have to see the percentage circular issued by them. That is their document, which is the official document, which is mandatory for each and every college across the country, including government colleges, private colleges. Kindly see that circular. Page 485. Very relevant second paragraph. If I am not there, I am out. I will withdraw my petition. If it is seen department-wise, I will withdraw my petition. I will record the statement. I can show thousands of cases across the country in last 10, 15 years that they will never see department. Why? I'll show from another document, also their own document. Kindly see this circular, 77. It is brought to your notice that in view of the problems faced by the medical colleges in appointing teaching faculty, stroke residents, the Ministry of Council and Council both mutual understanding permits relaxation of only 5%. PA Sangwa is having more than 11% efficiency, 7% efficiency. Why the permission was given then? Because they never see department-wise. It has to be seen in totality. My totality, if you see Your Lordship, I am 163. I am saying I am less than 168, but it is less than 5%. And the permission has been granted. Kindly see the judgment of the Delhi High Court, which relies on the Supreme Court judgment also. Dhanlakshmi. Wait, please. Kindly see for subsequent to the circular, the judgment has been come where the permission has been given to the colleges. See what the language is being used in totality. Never. This is the judgment, proper judgment 462 and actual 462. Dhanlakshmi. Kindly see this judgment. And the relevant page is 475. More than 23-page judgment after referring to various Supreme Court judgments and their own regulations. Kindly come to para 18. I will not take much time. This para itself explains everything. Although requirement is 202 faculty members is deputed by the petitioner college, basis of such has not been explained by NMC. However, since Mr. Maninder Singh has argued demur regarding factual NMC claim of faculty strength, the court has proceeded on the assumption that the requirement and applicable regulation petitioner college 202 faculty members. However, before proceeding further, it must be reiterated that offer mentioned communication. Medical Council College, such petitioner has entitled for 5% reduction in deficiency of the faculty, admits above by the paragraph 33 of the additional affidavit. They themselves admit before the court. NMC has given the additional affidavit saying that this is the circular on which we are relying while taking the decisions. Their affidavit was there on record. And this judgment is not very old. November 2022, when the NMC came. It is not prior to that. Not only this, now I'll show the third document of the department-wise. Kindly come to the assessment form, which is assessed by the assessor filling at the time of assessment, on the basis of which the entire decision is taken by them. Now that is at assessment form. Lordship, kindly see SAF, come to page 246 and 249. Volume 1. The entire faculty list is given. Prior to that, since my learned friend is saying it is department-wise, kindly see the pages start from, department-wise pages start from page It starts from 240 department wise.
Page 246.
And come to page 246. What is the finding given by the assessor? Whether he has written that since there is a deficiency of faculty in particular department, so you will not get the permission. Kindly see. Kindly come to those column of those this thing. It is only the deficiency of teaching faculty for UG seats 4.17%, which is less than 5%. He has not said that in Department of Anatomy there are 3 associate or assistant professors less, so you are out of this race for getting permission for this year. Never said this. No college will get permission on this earth if this is the finding or regulation says. It never says like this. This is a complete arbitrary finding given by both. And I will show from the PS Sangma, I have already shown to your lordship, there was deficiency of all the departments. And if you see the percentage, then every department is more than 20, 30, 40%. Why you have given permission? Because you have seen the totality of it. In my case, why you have not seen the totality? And the second point, 57 faculty. How can you write 57? You are saying that MARB and NMC decision, after that I have appointed. What is the MARB decision? Where is the MARB? My learned friend was referring to the April decision of 4th April. Kindly see what is that decision says that your faculty is recently appointed. I will demonstrate. Kindly see that order. MARB. And not only, come to page 249 also in this particular assessment form. This is the form given by them, not by us, and filled by them, signed by the assessors also. Kindly see. On the basis of this, only the permissions has been given this year across the country. If I am fit in this, I will get the permission. Otherwise, I am out. Now, kindly see 249. Increase admission capacity 50 I am seeking, which is a fresh LOP has to be issued. College infrastructure, adequate. Teaching faculty 4.17, they themselves will return. Everything is adequate. The money which I have invested in my college to get 250, that entire salaries which I am paying to the faculty for the last so many months, that will go. Where I am standing then? Where I'll get the justice then? And you are discriminating by your own orders. How can you give permission to PS Sangha? How can you give permission to Satyasai? How can you give permission to KPC, West Bengal? I'll show those orders. Kindly see the deficiency then. Satyasai, please. This is the 4 document which I am showing on the department-wise and the total faculty. 574. That is, I have placed these orders. And when I will show you the government colleges orders, lordship will be not only shocked, you will be surprised to see that how the government colleges are giving permission only on the basis of undertaking given by the secretary. That you give us the students, in the due course, we will appoint some faculty and then they will start teaching. You think that the students who are going to the government colleges for 2 lakh rupees will be there without any faculty? 100% efficiency permission has been given by them. I will demonstrate those orders. And those all orders are passed on the same date, 30th September, when my order was passed. Now kindly see this. First order. Now kindly see Satyasai, please. Yes, Your Lordship. Not only in this PS Sangha, I will show another very important point. 576, Lordship, kindly see. It starts from 572. Lordship. Sorry, 572 it starts. I have written the finding which has been given. Now kindly see the deficiency. 11% faculty deficiency. Why you have given permission when there is 11%? Straight away you have rejected it. At the stage of second appeal, can you appoint the faculty? No. The permission was given. Now kindly see, college is submitted 11% deficiency exists. Got the permission. Not only that, a new thing happened in this case. When we were rejected, we came to know because these orders were placed in the Delhi High Court. So it has become a public document now. It can't be said that you have taken by secretly from the ministry. This order, because this college order will go directly to the college, not to us. But from the Delhi High Court record, we got this order. It was placed on the record. Kindly see page 575. They changed the regulation also this year by giving relaxation, which was not given to me. They followed 2020. If 2020 is followed, then I'm in surplus as on today. Even on that day, I'm in surplus if 2020 MSR is followed. They said that the MSR 2023, which was published in the year November 2023, is kept in abeyance for 2 years. This year, now next year also, it is being now kept in abeyance. The new notification which came for submitting the application, the last date is 19th January. In that notice, they have very categorically mentioned that we have kept the MSR 2023. And what you are doing? How can you give permission to other colleges like this? Why discrimination? Because I am from West Bengal, not from Rajasthan and MP. No. KPC has been given, see the deficiency. Lordship, kindly see the order. 8%. Because KPC has been given, I was there to argue. That is why it was given. My chance, my learned friend was not there that time.
The allegations are against my client. I am the National Medical Commissioner. Now may I answer?
No, I'm not giving any allegation. No.
You said a lot of things.
No, it is there in your order.
He says we are not in Rajasthan. I will show your lordship what happened in Rajasthan.
No. Forget that.
Without giving us,
I am not saying
my
that.
lord, one day, my lord, he sits tight for now last 20 days after suffering an order on the 2nd for us to come with. Now, all of a sudden, the entire urgency comes for allowing the appeal in its entirety, my lord.
Why?
Without giving us a chance of hearing.
No. What documents have we filed?
And they have served these copies yesterday at 8.
No, Lordship, kindly appreciate.
Without instructions, my lord. I apologize, my lord.
No, kindly. Please.
Yes.
Which committee?
No. My lord will kindly come to.
Everything is there. Each and every document of my document. My document was there before. No, mine was on 26th November. There are earlier orders. Yes, that is mentioned in my appeal. Kindly see page 510. Each and every order has been referred. Yes, everything is there. Everything is there. Kindly come to page 510. And the copy is annexed at page number 517 of my second appeal. 510 is my second appeal before the Union of India. Yes. Can you see? Page 510 is my second appeal before the Union of India on 16th October. 15th, I was rejected. Next day, I went to Union of India. They gave me hearing after more than 1 month. Yes, kindly see the annexures at page 517. If your lordship will read the entire appeal, all orders are referred. Kindly count copies which has been annexed, page 517. SAF form is there. Delhi High Court is ordered there. Central government, Satyasai is there. And now come to the appeal where I mentioned about PA Sangma and everything. Kindly see. Avas is there. Satyasai order, Annexure R is there on record. In my appeal, I have mentioned about that. तो देखा दिया यार तो बोले तो Annexure R. That I have told. Not only that, I have mentioned about the other colleges also. And in the government colleges, I have placed. Now, Lordship, kindly come to page 513 onwards. So 514 is that I have quoted the entire. Last para. Okay. लिखा हुआ है about the guidelines. ये सब मैं कहा है भूल गए लिखा हुआ. Yes. PA Sangma that time I was not having it. which I came from the Delhi High Court record. And that is why I have mentioned all these in writ petition. So 26th November was the order. Now, Lordship, PS Sangha I have mentioned, kindly see, page 515. In the light of the above, including various orders passed, last paragraph. अंदर में देखो ना लिखा है PS सभा के बारे में, उसके अलावा भी लिखा है. And also the judgment of the IQCT in which I got the relief from Delhi High Court on similar footing. And these are other orders. And now, Lordship, kindly see one more, please. See the government orders, the government college's permission. That is on record, which was there. Kindly see 630, 630. Please. These are the government colleges. They have to follow the regulation. Nothing to be discriminated between the government and the private. Their FAQ says about this. I'll show. This regulation has to be followed by each and every college which is under the NMC Act. Please. Yeah, kindly see the deficiency. Professor 0, associate professor 0, assistant professor 0, tutor 0. This is the finding of the MAR. Their finding, MAR's finding. Come to next page. Gross. What is the first chapter? What is saying? Gross faculty deficiency remains even today. Dean principal is not available. Abbas registration is still not done. Committee of observation, this. TOQ, and now come to the Government of India stand. What is their stand?
615 within the
6 and 5, 100% efficiency.
box.
Now come to the Government of India finding. They are saying, first appeal, after first appeal, they are saying, the college in its second appeal informed that at present there are 21 faculty. Only these available faculty is registered. So only 21 for 100, and they are seeking how many seats? 100 seats. For 100 seats, the requirement is 605, which I have shown earlier. Yes. And these are not only one, 9 orders I have placed on record, 9 colleges. This is only one state, Maharashtra. If you go to UP, 7 colleges got permission without faculty. If you go to Rajasthan, 5 colleges got permission without. And I've got the entire list, the colleges which got the permission. So you cannot discriminate me and then saying that I'm coming late. My interim prayer was that what? I was not asking for ad interim. My interim prayer was, during the pendency, you direct them subject to the outcome. Increase my seats and get the students. Students will decide whether they want to take admission or not. If I'm out this year, then my entire year goes. And not only, it with the loss of more than crores, not only to my college, but it is loss to the nation. 50 doctors you are getting shot. And Supreme Court, why they have extended the date? Saying that we are shortage of this. And why you will discriminate? Why Government of India has any answer to this? PS Sangma, Satyasai, KPC, because I was able to assess only 3-4 of them. You see the list. FAQ, first see the FAQ. This is their document, not mine. Why this being published? Because you should know, everybody should know. It's all in their website. Nothing is hidden. Thank you. Lordship, see the second question. Yes. एक सेकंड हम पढ़ा है और है कॉपी चौथा कहाँ
ये कॉपी दे दी हम लोग शेयर कर देंगे
अरे तुझे कितना चाहिए
I do not know what is being handed over to Lordship.
No, I'm giving. These regulations are second question. So these regulations has to be followed by everybody. Why there is a pick and choose there?
None of the documents that is annexed.
May I answer every point? And there is not a single document which they can file by improving their affidavit, because each and every document is on record.
Their orders.
And their orders, everything. I have not hidden anything. My faculty list, NMC orders, first appeal order, second appeal order, everything is there.
Available with them.
Why this order then? Why are you writing about the faculties? You are saying that MAB and NMC, after that, show me one. I will show you 50 names which are appointed prior to that. My staff itself speaks about that, which is on 30th September. Order was passed on 15, not prior to that. My learned friend, which order my learned friends are referring, kindly see that. He relied on those orders, saying that it was MAB take the decision in April. Why are you kindly see that order? There is nothing, not a single word about faculty. Simply they are saying in all the columns. Kindly see the MAB order. 123. 123. I'll show only that page. And then I'll show the NMC first appellate authority order also. Please. Letter of disapproval. Right, left side is the requirement. Right side is their comments. No faculty details is required at the time when you are submitting the application. It is only when the SAF is filled. It is only when the show cause is given to you for compliance of the deficiency. And I will show what guidelines they have issued in the month of April. That is also very important. That is why in Sangma, all the date of orders were considered. In this also. On the date of order, 28th August, faculty was counted. Yes, now Lordship, kindly see this order. Columns, only one moment. All columns on that right, 123 onwards, 122. What they are saying? You have given permission, we will not give. You have given permission, we will not give. We will not entertain your application. Where they are saying you are having a faculty shortage or you are not appointing faculty. Now come to the appellate authority order, next page. That is 134. First appeal authority. Such a vague order, non-speaking, complete violation of my natural law of justice. 2 one-line order. Appeal committee heard the college authority and re-verified documents and records as per regulation cannot be increased. Why? Because last year you got. So the MAB decision, they have uphold the MAB decision. MAB never says that I don't have the faculty. I got only opportunity when this show cause was given to me on the direction of the court to fill the form. That SAF was submitted on 30th September, which I have demonstrated, Lordship, what faculty I was having on that day. Then the hearing was, and now kindly see the first order of the appellate authority, which my learned friend was referring, that the government of India has already remanded the matter back, saying that you don't have faculty, you don't have material. Kindly see that order. What finding has been given by them? Page number 146, Lordship, kindly see. Very, very relevant to this case. Again, very detailed order. But in this, what they are saying, why this 3-page order is there? The government of India was surprised after seeing the order of the MAB and NMC. That is why the matter was remanded. See the finding at 148. Committee further observed that the assessment of the college has not been carried out. How can you decide without carrying out the assessment? And nothing has been availability of clinical material faculty is not before the NMC and the MAB. So that is why it was demanded to get my faculty, my assessment done by the NMC, which was done on 30th September. Their order itself speaks the volume. You are remanding the matter to NMC to get my assessment done and see what is my clinical material, what is my faculty. If Lordship, I am not having this, then I'm out. Then why should I come before the court? Why should I run to Delhi High Court, Calcutta High Court? And kindly see the delay also. If you see the regulation, the entire scheme has to be decided within 6 months. The very first decision comes in the month of April. My application is of 19th September, more than 6 months. You yourself are violating your regulations. And you are saying, I'm getting delayed. Every second day I am filing the appeal. Only thing is, during my interim submission on second before the court, I asked for that. The court said, this is a voluminous, let them file the reply. After insisting, he refused and he gave me 2 weeks. Not 2 weeks, forget, on 20th also the affidavit was not ready. I was ready to argue on 20th saying that I will not file any replication because the entire documents are there on record. They cannot file a single document showing beyond this. And that day also they refused, and simple sitter order was given for another 10 days. On 2nd January, what I'll do then? I am nowhere, zero. My entire year will be zero. But if your lordship will grant the permission, there are the orders where the extension is given for counseling also. Once the LOP is issued by the NMC, no authority can say no. The state government will have to then allot the students once the LOP has been granted, even it is beyond 30th. That is why the 20th order was challenged. Otherwise, I would have come on. I was under impression that since we'll get the reply and I'll argue the matter.
They got opportunity. It's not a case.
So all opportunity was given. Lordship has said, I remember, that you have passed a recent judgment where you said that if the opportunity is not given, then interlocutory order will not be maintainable in appeal. Here, 2 times the opportunity has been given. India Cable, your Lordship judgment division bench. Lordship is aware of this judgment. Para 14 and 18 is very clear. And there is one more judgment of Supreme Court where Justice Lahoti has said, but Lordship has said that if opportunity is not given, then final relief. But if the opportunity, 18 days time is less opportunity to file the reply. Simplicity only, without filing any document, when each and every document is there. Now, Lordship, kindly see the Supreme Court says in 2004. Yeah. Here I am establishing this, my discrimination by violation of Article 14 is there before your Lordship. Kindly see, complete non-speaking orders, principle of natural justice has been violated by both the authorities. Not only that, all documents were there. Why are you giving this finding to me? Why are you giving permission to other colleges? You should have maintained. I'm there before your Lordship for the parity also. And Lordship, one judgment, para 12, kindly see, Supreme Court said. Para 12 and 14. 30. Yes, that is the crux of the matter. Situation emerged, kindly see what the Supreme Court said in para 12. इनको दीजिए, copy दीजिए. इन्हें इनको
citation बता दो फिर.
No, 12. First read para 12, your Lordship. Situation emerged where the granting of an interim relief tantamounts to granting of final relief. And then there may be converse cases. Yes. So here, if your Lordship will not give me the interim relief, then I'm out of the list because my final relief has nothing will be left in that final relief. What I will get on 2nd January? They will say you have not taken, and this started from, not only that, this started from the month October. Please. The Lordship, that is why. The Lordship judgment is there, 2019. 2000. Lordship has the right to set aside. So Lordship may grant the interim relief. No, Lordship. No, Lordship, then give me the interim relief subject to the outcome. I will be there. Supreme Court has given, High Court has given so many times. Yes, Lordship are right. No, then we will mention it in the notice. Please. It is there. So many cases are there. But this is not the case. Here, I am giving you the document showing my faculty. Show the latest AVAS. I'll show the latest AVAS. I'll show the latest about what faculty I am maintaining despite not having the permission. No, the Lordship, then where will I go then? Where will I go? Yes. Where will I go then? This is the latest position of my AVAS, and I have told your Lordship that once you are registered in AVAS, you cannot be shown anywhere across the country in any college. So it can't be a fake. Yes. And they are marking attendance. That is why this AVAS is there. This is the attendance of attendance. Date. AVAS का कहाँ है? Attendance. No, Lordship. I'll rely on. No, Lordship. Let my learned friend has. No. I'm not saying about judgment. That is why I'm here for the interim only. Yes. Let us see whether yes. Good.
Well, first let MNC because they are them, and then I will come here.
No, I have not. What? I have not. I have not. Kindly permit me. My learned friend has been arguing from 12:30.
I will kindly give a
points. Kindly permit.
yes.
I have not. Orders are not fake. Number one, kindly permit me. Kindly permit. Kindly permit. Number one, orders are not fake. Number two, orders are not passed by me. Orders are passed by the central government. I have rejected each and every application. I am for the National Medical Commission. No, he has shown these are all second appeal by central government. No, I am the original authority. Kindly, permit me. He has made so many submissions. I have. Because this is not applicable to new medical colleges. All my learned friend is showing is all new medical colleges. This is not a single case of an existing medical college wanting enhancement of seat. No. Please take your seat. But I cannot argue in this way. I'll show your Lordship. He has shown, I will show your Lordship. Kindly take. KPC is an old one. Lordship knows, Balat. Lordship knows. Kindly see, these are new medical colleges. The Rajasthan High Court has held that this is not applicable for enhancement of seat. That's one. The second is, Balat, your Lordship will see he has taken a number of points. But what he has been arguing and what he has been showing are all previous orders. He said that I'll show your Lordship. But the sequence of facts is not like this. I'll give your Lordship few dates. I got the brief in the morning. I didn't get a time to make a list of dates. I'll tell your Lordship. But his first rejection was on 3rd of April 24. He applied. The original authority, that is the MARB, the Medical Assessment and Rating Board of the National Medical Commission, rejected his application on 3rd of April. Then Maladi preferred a first appeal to the National Medical Commission, the apex body. The National Medical Commission rejected the appeal on 20th of June 2024. Thereafter, Maladi second appeal was preferred to the central government. There an order was passed on 30th of September, remanding it back. Then Malad, they went to Delhi High Court as well. Delhi High Court also said, decide. Then Malad, it came on remand to the National Medical Commission, and the second rejection was on 15th of October 24. Now he makes a submission that the points which are taken in the second appeal or the central government has decided it is not there. Now kindly see whether it is there or not. He has been showing the earlier orders. Kindly take page 94. This is the order from which the second appeal was preferred. Now, my lord, kindly see, kindly turns over to page 95. Kindly take the second paragraph. The committee has also considered the previous records, such and such. Kindly see, my lord, 15 out of 20 departments are deficient in faculty, resident, tutor, as per AEBAS record data between this and this. Right? So,
consistency in the stat, you are not a second appellate.
I am the first appellate authority.
You are not supposed to answer.
Yes, yes.
But anyhow, you
Yes.
are bound by this.
Of course. Of course. Yes. Yes.
And you are making the supervisor this matter is concerned on the basis of the department.
Yes.
There he says that why they have different parameters to treat in respect of a same thing.
Malad, it is. Yes. Because that is a new college. That is what I am trying to differentiate.
If you see, as we all know, once education recognized that will not be true. KPC, you have all in Bangalore, we have gone.
Yes.
We know that the KPC was established.
Yes.
It is not a definitely a new college.
No.
Even when I was on that side of
Yes.
that side of the room, I had
Yes.
so I know what is the
Order has to be placed, Malad. I have not seen the order of KPC. Where is it?
This is what I was showing in Lordship. Kindly see.
No, no, then you complete
Yes,
your
559.
arguments. How can we start from the
Lordship,
middle?
No, no, it is there on record. 559.
Let me see.
557 Lordship there. I was reading, Lordship said, no, it is enough. You have shown so many colleges. Kindly see 557. Increase of seat.
No, 557.
557.
It starts at 553. Please.
Twice it has
Please.
been annexed.
Now, Malad, kindly take 553.
Kindly see the first.
Kindly take your seat, please, sir. We do not disturb people like this. I don't know what happens in Delhi. In Calcutta, we don't do that. I'm sorry, Malad. But if he comes into my brief and starts pushing me, Malad, it's difficult. Of course. That's why I said, sir, please take your seat. No, not at all. Not at all. Sir, please take your seat. Kindly permit me. Of course.
I am helping him.
No, I'll ask for your help when I need it. Malad, kindly have a look at page 553. Konta. Malad, it says it's a new medical college in the second part.
I'm talking about 550. That is why I'm assisting him. He was reading the wrong.
556, 557.
Yes.
Yes.
See the subject.
Increase. Yes.
Increase 50. Yes. Yes.
Yes.
From
Yes.
So this is the same case. And then what deficiency of professional Indian deficiency 7 then deficiency of assistant professor 5 after declaring
Faculty.
the total was 150%, which amounts to deficiency of 2 years. BSR and the deficiency 2%. Considering the said deficiency about the decision of P7 the increase of such and such day. 559 is the finding of the second appellate authority.
Yes. The college has submitted that they have one as law and 135 SR of the Washington against the all these things are registered making their decision. Committee observed that such and such the requirement of for 255 is 142 and the case is the college has only 172 and 135. The committee also observed the college has the college has submitted the documents and report. This report is done. And then NEC 50 finds that the college is kept in the permission and sentences by the concluder, keeping of the fact that such and such recommends may be directed to issue permission for such and such. What is the deficiency there?
Yes, deficiencies are there.
Yes.
Why?
This one, of course, the central government can, because we had rejected. Yes, yes. That is there. That is there. But no, I have not discriminated. For everything is. But may I only place then one? Very well. You will answer. May I?
If you have given
I just want to place one judgment before your lordship. Kindly, my lord, permit me. This is a Rajasthan High Court judgment very recently, my lord. Two judgments, in fact. No, not on a discrimination. Identical facts like this case. There was a deficiency on their part in that college also. They were fined, and after that, my lord, they reapplied. They filled up the deficiencies later on. The division bench of Rajasthan High Court held that filling up the deficiencies later on will not do. It has to be done earlier. And on that basis, my lord, they rejected it, stayed the order of the earlier court. The original writ court had, my lord, allowed it. Yes.
What does the word mean? First thing is factor discrimination. Second is judgment. They second appellate authority the second examiner see that more than 50%. And did not take into account the total. Yes. Therefore, in case of the
Yes.
Very
well. We will answer that. I am not on that. Very well. My learned friend will answer. But may I say? Yes. Yes. But may I say this? Only kindly, my lord, consider two things I want to say, my lord, before your lordship. Assuming, my lord, your lordship ultimately decides on the discrimination point to set aside this order and remand it back, my lord, because perhaps your lordship will not be the authority to decide whether these seats are to be done right now. That's one. Yes. Ultimately, my lord, because if ultimately, my lord, the writ will go, the appeal will go, everything will go. But my lord, I have understood. But my lord, I have two. Yes, but I have two submissions before your lordship, which would be German. My lord, kindly have a look at the Supreme Court order which has been passed recently. No, because the counselling has ended. I have to tell that to your lordship. No, that I need to show to your lordship. If your lordship accepts it, my lord, then it's. Yes, that is what I wanted to place before your lordship. Kindly. Yes, no, up to 30th of December. And that schedule also I want to place. The choice filling up counseling part has closed at 11 a.m. today. That is what I want to place before you.
That is all.
Kindly have a look at first the Supreme Court order. Very well. Let me place it in my way. And may I, please, sir, let me complete. You will get a chance, I'm sure. May I read it, my lord? Very well. Yes. Now, Malad, this is the schedule which has come out. Kindly have a look at this schedule.
Annexed. It is already there
Very well.
on record 636.
Kindly see the
32, 33.
first column itself. No. But yes. Today. And at 11 o'clock, the choice filling has closed. Now, if this is to be extended, Malad, in my humble submission, it is to be done by the Honorable Supreme Court under 142. So therefore, even if they get the 50 seats today, it has to go to the next session. It cannot be in this. This is my Malad submission so far. And one Malad and one Malad Rajasthan High Court for my kindly have a look. This is exactly on the point, identical. No, but identical to this case. No, what is to be considered, Malad? Very.
I need if today my lord a question comes, my lord, so if discrimination, I have on facts, my lord, yes.
Why this?
It comes today in the morning. My lord, yes. But I have to have instructions. My lord, I appeared on the 20th. I did not appear before. I was not there. And my lord, on the 20th, no. My lord, as far as this discrimination, my lord, I had asked them for written instructions on this. I know that. Therefore, I wanted instructions on this particular aspect, and that was the prayer which was made by me before the Honorable Single Judge.
Brother, 2 means unanimity.
Discrimination to the medical expert to medical expert.
That is their possibility. It can't be. This cannot be.
Yes, how can I? From the cuff. I will really appreciate 2 things for it. First of all, on the 2nd, the order which they are challenging, this was there before the Honorable Single Judge. Time was given. On the 20th, on this particular aspect, I said, my lord, my instructions are wanting in particulars. So, my lord, it was granted, and on that day, they did not oppose. My lord, my lord, if they, my lord, appear in this manner, my lord, I am retiring, my lord. Then, my lord, I cannot, because if exuberance in this fashion, my lord, in court.
Please, let my learned friend finish.
My lord, my predicament, my lord, I am arguing, my lord, but my lord, whispering and proxy over here. My lord, what I am humbly submitting, my lord. Now, my lord has come on the point of discrimination. My lord is on 580, and my lord is on 580, that KPC, where, my lord, specifically it has been said that 150 to 200 seats.
Places it is the next at 2 places. 550 is also same order.
Well, it is same, my lord. KPC Medical College, again, I also find it at page 580, my lord. The order which is September 30, 2024 is, my lord. My lord, it has been, maybe there's another page has been 580 also the same order. So, my lord is on this discrimination that why in this case when it was granted, why it was not granted in the case of the petitioner. Plain and simple. Now, my lord, this particular aspect, what even if I read it.
And discarded
Well, Milord, what I'm humbly submitting is, Milord, I totally follow, Milord. I totally bow down. But, Milord, shall I read it? What? Two things are there, Milord. First of all, if there is a discrimination or there is a reasoning behind it, for that I need instructions. Now, Milord, instructions we were given time for bringing instructions on this aspect only, because I was on this point only before the Honorable Single Judge. My lord, I suppose this is a government college, and there was some undertaking which I could understand.
No, you're talking about this order.
My lord, what our problem is, my lord, when I am gone, my lord, as soon as I want instructions, my lord, my officers say they will have to consult the records. My lord, I am not holding a private brief where I am well versed with my client over here at my back giving me instructions. Now, my lord is asking me a question which is following from my lord. Very humbly, I am saying, my lord, as far as the factual aspect is concerned, without me being heard on affidavit, my lord will grant final reliefs to them. And where the counseling is also over. And they waited till from the 2nd till today, my lord. They waited, my lord. Will kindly understand my predicament. That is my first. My lord, considering that, my lord, will kindly give me a chance of at least coming before my lord. My lord can pass that order under any circumstances, even on the 2nd. It is not that order, that power my lords always have, my lord. But my lord, I should get a chance to at least see one more day to.
Please.
My lord will not make it 26th, my lord. My lord will kindly make it.
No. It is the same thing is happening here.